but I do not know why it's not listed today.
We'll take it unlisted.
No.
Mr. Doctor, while I was dictating the judgment yesterday, I could see that the steps were taken in respect to the injunction which was given on 29/10/2024, 29/9/2024.
Silchar matter, my lord.
When was the injunction granted?
Injunction was granted on 30th, my lord. Step was taken on 6/11.
No. Injunction, when was the suit filed?
Suit filed on 3rd of
October.
On 3rd October. The injunction was on 5th, 10, the suit was filed, 3rd or 5th. Then the injunction was granted on 30th October.
You just check it out and ask him.
Yes, I will just go.
When was the suit filed? Because the suit seems to have been filed on 3rd of October.
3rd of October, correct.
And the steps were taken something, and the injunction order was
No, what
passed on
happened, my lord?
29th of
No,
October.
what happened after the injunction was granted, on the next day within 24 hours, the advocate concerned, he has issued a letter, intimated the order of the injunction to the parties concerned, without any order of the court. But the step has taken after 5 days on 6th, 11th, as per the records of the court. That we have filed in the.
That I could see.
Yes.
It is taken on 6/11.
Yes, 6/11.
Okay, but the suit was filed on such and such.
Yes.
Then why there was such a gap in granting an injunction and no
The court
notice?
fee something was there, filing of the court fee, that issue was there. Ultimately, the case was taken up on 29th.
What was the
October.
holiday list for 2024 trial court?
No holiday, Parathman.
Third, fourth was holiday.
There is a discrepancy. 3rd, the date of filing, the affidavit shown on 5th.
Affidavit is of September.
September was, it was shown on 5th, perhaps. 5th, 10th. It was written by the party on 29th or something, September.
Get me the date on which
I will.
it was filed.
I will.
Because why? I don't understand. Then if it was the suit could remain there, then what was the necessity for an ex parte injunction?
I will find the list of dates.
MSc appeal about 2022. Maybe on list on 2nd of June for order.
It's a appeal
MSc appeal.
for hearing
No.
orders.
Getting step service.
Okay. When do you want it? We have it on at a date of in June.
2nd will I have given.
Huh?
2nd of June will I have mine.
2nd of June.
Only this matter. Yesterday I have filed this matter on.
What?
There is some urgency in this matter, Lordship. Yesterday I have filed this matter, Lordship.
You want to do it today?
Today, Lordship, 2.
Right, Lordship, I beg to mention one condemnation petition, my lord. We have taken steps by Dusty, my lord. I have affidavit also filed. My lord, it may be taken first week of June, my lord. It was last listed on 17/9.
Okay.
Obliged.
2nd of June.
Highly obliged.
Mr. Lordship, I
For motion item 1 to 8.
Yes. Tell me.
I would like to mention an MSc appeal for listing for orders. Listing for orders. MSc appeal.
MSc appeal. Okay. 9th of June. 9th of
Item 1 to 8.
Please.
Yes.
There are 13 matters which are listed before your lordship of Power Grid Miller. In all these matters, 4 issues are involved. One, that the case of the Power Grid is that it is barred by limitation. The lordship has taken a view that in view of Article 137 of the Limitation Act, it may not be barred in one of the matters. The lordship has taken a view. Second issue is, my lord, that the trial has been conducted by a learned district judge. without framing the issues and without permitting the parties to lead the evidence, my lord. So our case is that there is a mistrial also, my lord. Because of that, we have not been able to lead the evidence because we have prepared a chart, my lord, showing.
When did you pay?
I have paid the amount on various because 13
No,
cases.
no, we are concerned with the first matter. When did you make the payment?
First matter, my lord, dates are there, my lord. If I. So, my lordship, in the first matter, date of payment is of 19th January 2015, my lord.
When was
And-
it filed?
And it was filed on 3rd March 2018. 3rd March 2018, after a period of 3 years, my lord.
First, you paid the money on,
On, that is on 19th January 2015.
can it be? Because it was filed on, not on that. It was filed on 15th of March 2017,
That is item CRP, my lord, it is CRP.
51 of 2025.
Sorry, my lord, CRP is, my lord, 3/5/2017. It was filed within time.
Then,
And therefore, my lord, so far as limitation is concerned, I have no ground so far as limitation issue is concerned. Now, if your lordship will see in CRP 35. 30, so sorry, 51, my lord. Your lordship is on CRP 51.
51 only I am looking
Yes,
into
your
it.
lordship. I'm sorry, my lord, because there are 51. If your lordship will kindly see CRP 51 and CRP 51 and the finding which has been recorded by learned district judge
Hmm.
is at page, my lord, no evidence of, because the region which has weighed with the learned district judge in enhancing the amount, my lord, in item 51, because we have assessed 5,76,314. And learned district judge has increased, my lord, to 7,61,210. The reason which has weighed with the learned district judge is, my lord, is that the statement which was made before learned district judge, that the age of the trees are 12 years, my lord. And no issues have been framed, if I can take your lordship to the, and no evidence has been allowed. So,
Did you raise the issue that
the-
the trees were not of that age?
yes, my lord, there was.
Let
no-
us see in
if
your pleadings.
Your lordship kindly see the finding of the
No,
learned.
no, first of all,
Pleading,
let,
pleading,
me-
pleading. Yes, my lord, pleading.
let us see your objection
Yes, my lord.
where you have stated
Yes,
what
your
is
lordship
the.
kindly come to page. The objections are, my lord,
Hmm.
at page 29.
Hmm.
Page 29.
Yes, where is it?
First is no cause of action, my lord. Page 29 is,
Mr. Counsel, I am putting
Sorry.
you a specific
yes, my lord.
question.
I
I'll
let's see what is,
expect you to answer that.
yes, ma'am. Let's see what is calling from your lordship. The lordship is the award. Yes. All right. Yeah, your lordship, kindly see the age of the tree was not mentioned in the plaint, my lord. And the learned district judge, my lord, in paragraph 15, if your lordship will kindly see paragraph 15 of the judgment, my lord.
Hmm.
Which is at page, my lord. Judgment page. Is 37, my lord. No, first it says 30, you can't put. You know what I pray today, my lord, because there are about 13 matters. And actually, as a lead matter, I was ready in 37 with the pages and relevant pages, my lord. If your lordship will kindly give me one date where I will have all the CRPs separately, otherwise, my lord, I have prepared a chart. Page 78, my friend is. Paragraph 9.1 at page 75, your lordship, may kindly see.
Yes.
In support of these contentions, petitioner has adduced evidence personally and also through the official of Agriculture Office, Alakandi and Forest Department, who have submitted the relevant data showing that price and yielding capacity of various so and so miller, which is relevant for the instant case. In the case in hand, it is admitted by the opposite parties by way of written statement that trees and plants are so and so miller. And according to petitioner, my lord, in the middle of the page, her betel nut trees were cut down at the age of 12 years. my lord. If the
Page,
trees were cut down at the age of 12, in view of the expert opinion, it is clear that betel nut could have been yielded food for almost 8 years. my lord. So the material which weighed with the learned district judges, that the age of the tree as per the assertion of the petitioner is 12 years. Now, my submission is, my lord, that if the issues would have been framed, because I cut those trees, my lord, and after
only one judgment wherein in these matters which are of summary jurisdiction, issues are required to be framed.
I'm grateful, my lord, because there are two judgments of the Honorable Supreme Court on this issue, my lord, with regard to the applicability of Section 10 and Section 16 of Telegraph Act. In one of the judgment of the Honorable Supreme Court of 2017, my lord, it has been said that it is a suit, my lord, not it is a suit when the original proceedings are there, my lord. So therefore, that your lordship will. Yes. And I pray your lordship to kindly see the judgment of serial number 6 at page 54, my lord.
Yes.
And your lordship will find, my lord, because this was the dispute with regard to assessment, and in that entire act was analyzed. And after analyzing the provisions of the act, my lord, paragraph 28, my lord, at page 67. Paragraph 28, my lord, there are sufficient reasons to allow civil appeal of 19 so and so preferred by Power Grid. By setting aside those directions order accordingly, we make it clear if the writ petitioner feels that it is entitled to any compensation, appropriate course of action is to file suit for district judge concerned for this purpose. It would be apt to point out that the state or central government has framed guidelines, my lord. And if your lordship will see one more judgment of Karnataka High Court on this issue, my lord, though in slightly different context, my lord, that is at page 89. My lord.
Yes.
And your lordship kindly see the Karnataka High Court judgment, my lord, at page 89, serial
So,
number 8.
Mr. Counsel, you mean to say,
Yes, my lord.
because the court says that it is a suit
Yes, my lord.
and given the liberty to the council, instead of filing a writ petition
Yes, my lord.
to the
to the court.
writ petitioner
Yes.
out there,
Yes, my lord.
that he can file a suit under Section 16,
Yes, my lord.
this court has to think that it is a suit.
Because how
I think let me dismiss your petition, you go before the Supreme Court, the Supreme
No, no,
Court
no,
can
no.
clarify
I
that.
will try to persuade
No,
your lordship.
Then
Kindly
next one,
allow me to persuade your lordship.
no, I am not persuaded with that. Next, because
Next.
these are summary jurisdiction. Jurisdictions of the court are limited. Just for example, a limited jurisdiction under 34. You don't require to have, under Arbitration and Conciliation Act, you do not require for framing of any issues. These are not conceived of.
Yes, my
In
lord.
a reference proceedings under Section 18, or under section 64, the question of framing of an issue does not. The only issue before the court is as to whether there is requirement of an enhancement or not. That's all.
Yes, my lord.
There's nothing else. If you very well, if you raise an issue of limitation, the court can very well look into it to that effect. But if you merely, in this case out here, in this particular case, the issue of limitation, obviously 137 will apply. But 137 says that it will apply, it will be 3 years when the right to apply accrues. Now, the right to apply accrues is when there is a dispute. Now, where have you mentioned in your pleadings that there is a dispute arose on such and such date?
What is falling from your lordship, what I quite see, my lord. Now, there are two aspects, two submissions, my lord, apropos to what has fallen from your lordship. One is, my lord, that the Telegraph Act requires that the sufficiency of the compensation which is required to be seen by the learned district judge, my lord. Now,
Only as regards the inadequacy of the compensation, nothing more than
yes,
that.
inadequacy of the compensation.
That
Now,
is what
in
he has,
order-
yes, there might be a case where there is a delay. You can very well raise
Yes,
and
my lord.
say that this is the dispute which has arose.
Yes.
Because section 16 categorically says that the right to file will only arise when there's a dispute.
My lord, if
Merely
section-
tendering a payment would not amount to a
if I
dispute.
can place
Hillary.
section 10D, my lord, section 10D for your lordship kind consideration.
Hmm.
Section 10D of the Telegraph Act, my lord.
Okay.
Ten D, if your lordship may kind. Telegraph Act. Section 10D, my lord, of the Telegraph Act.
Yes.
Section 10D, my lord. In exercise of the powers conferred by this section, the Telegraph Authority shall do as little damage as possible. And when it has exercised those powers in respect of any property other than that referred in clause C shall pay full compensation to all persons interested for any damage sustained by them by reason of the exercise of those powers. So what Telegraph Authority, in my humble submission, my lord, is little damage as possible, my lord. Lordship, kindly bear this one fact also in mind, that the trees have been cut, assuming the trees have been cut after, and the tree has a life of 20 years, it was cut after 12 years. 8 years loss has been accrued to the person who's, for 8 years, that land was available where he can offset, he can have certain other agriculture activities, my lord. That factor has to be taken into account. But my point is, my lord, kindly see section, lordship has rightly said section 16. 4, my lord. Sorry, section 16(3), my lord. If any dispute arises concerning the sufficiency of the compensation to be paid under section 10. So sufficiency of compensation to be paid, my lord. So requirement is determination under section 10D. First, this is a statutory duty of the Telegraph Authority to determine. Payment will come to be paid, my lord. Payment may come at later stage. Even determination will give rise to the cause of action, my lord. Determination will give rise to the cause of action. Sufficiency of the compensation to be paid under section 10. Clause D shall, on application for that purpose, either of disputing parties within whose jurisdiction is situated, be determined by him, my lord. Now, your lordship is of the view, my lord, that the determination, my lord, requires the pleading by the claimant and rebuttal by the defendant, respondent in this case, my lord. Now, pleading, my lord, first requirement in my humble submission is that under 10D and under section 13(3), my lord, the minimum damage, my lord. So the petitioner comes and, the plaintiff comes and puts his case that my tree was of 20 years and it was cut after 12 years, my lord. So, and so therefore, in that event, in my humble submission, the issue should have been framed on the entitlement with respect, because there is no
The only issue is as regards entitlement.
entitlement based on the evidence to be led by him that his trees were of 20 years, 12, it was cut after 12 years. Second,
So
offset,
where is the concept of framing of issues?
because, my lord, the issues will come, my lord, when there is the affirmation and denial by the other party, my lord.
No, understood, that is in the suit.
No, my lord, here in my.
Because of the fact that the Supreme Court uses the word that he can file a suit under section 16, does it
That is
mean that
one
we
aspect
have
of
to
the matter.
understand that?
Your lordship will see Karnataka High Court using the similar view, my lord, in that judgment, if your lordship,
Let us see that
that your lordship kindly see at serial number,
page.
page, my lord, is Karnataka High Court is page 89. Paragraph 5, my lord, at page 90. In my opinion, trial and decision of the case suffers from error of law and substantial material irregularity amounting to mistrial. As per the provisions of the Code of Civil Procedure, in particular order so and so, it is the duty of the court to frame necessary issues which arise from the material proposition of fact and law, as affirmed by one party and denied by the other. And the rule is quoted, my lord. After quoting 6 at page 91, a reading of Order 14, Rule 1 per se reveals that it casts a mandatory duty on the trial to frame all necessary issues arising from the pleadings, namely material proposition of fact and law, so and so judgment, my lord. Plaintiff has alleged and asserted that in the pleading that land on which electric pole is and had been installed by the electricity board belongs to the plaintiff, and plaintiff is the owner of. Defendant electricity board has asserted as per pleading quoted above that the land does not belong to the plaintiff. It is the public road. No finding can be recorded without framing necessary issues and indicating the burden of proving that parties and giving opportunities to them to produce evidence. Really, it is and has been duty of the trial court to have framed issues on question whether the land on which the pole has been installed or electricity board did belong to the plaintiff or it public road. Hence, following two issues have to be framed, whether the land in dispute pole has been installed, so and so, my lord, whether land is public road. Now, if your lordship kindly come to paragraph 9 at page 92. No doubt electricity board or,
Mr. Counsel,
Yes.
first of all, let us read paragraph 2.
yes, ma'am. The brief facts of the case are the plaintiff's appeal arises from judgment and decree of trial court, namely.
Where is the
18
district judge?
Yes, my lord. No, your lordship.
This is purely a case.
So, your lordship.
This is in fact, the proceedings was not maintainable. Let us not go into all these things. Section 16(3) stipulates a very limited jurisdiction given to the district judge. That look here, as to you are here to look into as regards the sufficiency of compensation, nothing more than that.
Yes, my lord.
There, whatever further may arise, let's just, for example, you raise the issue of limitation out there, the court will look into it, provided you have the facts to that effect. That the dispute arose on such and such date, they filed after such and such.
Yes.
These pleadings is given, has to be given.
Yes, my lord. That there is no dispute about that. Pleadings have to be given, my lord.
But no case.
Just kindly see paragraph 9 of the judgment also, my lord,
Why
because
should I look into it?
the
No, First and
paragraph act,
foremost, with due respect to the Karnataka High Court,
my lord.
the first thing is that the suit should have been dismissed because of the fact that 16(3) was there.
Yes, my lord. That is what.
Jurisdiction was exclusively
Your lordship
with the
is right.
district judge.
Yes, your lordship, that is what the Karnataka High Court in paragraph
Well,
9.
here the court was looking into in a similar provision of a CPC, where a suit was being filed, seeking damages for whatever may be because of the electric pole. There were certain issues were framed, which the court felt that there was additional issues should have been framed, and as such, the court exercised the power of the order 41 rule
Yes, my lord. Kindly
23
see paragraph,
and remanded it
yes,
back.
my lord, kindly see.
I am not on the other aspect.
No, kindly see paragraph 90, para 9, page 92, my lord,
Yes.
of this judgment, my lord. No doubt electricity board or may be entitled to make use of property, my lord. Last 4 line of that. These finding observations appears to have been arrived and made without framed an issue on the point and without plaintiff being given opportunity to lead evidence. Such an approach is really resulted in mistrial, my lord. Now, electricity board even was or may have been entitled, no doubt, to make the property to but applied section 10C of the Telegraph Act. Court below should have taken into consideration and decided after framing the issue of minimum possible damage, which could be done or was done to the private person's property. And if so, its effect, and if the compensation as per requirement of Telegraph Act has been assessed and paid by electricity board, my lord. So my humble submission, my lord, that this aspect, my lord, should have weighed with the learned district judge while framing the issue, and in this light, my lord, if any compensation as per private and as per the requirement has been assessed.
Mr. Counsel, not satisfied with that. Next,
Yes, my lord.
now let's come to section 3.
Your lordship, please.
No.
Right, what? Your lordships, my humble submission is, my lord, my submission is that this is a civil dispute, my lord. Even in Arbitration Act, my lord, the section 24 of Arbitration Act requires determination of the issue, my lord, before. How do I lead the evidence, my lord, to show that no, your tree is not 12 years old?
Why
Because-
why on earth didn't you ask before the trial court,
Yes,
before the district judge?
My
Kindly
lord.
frame issues,
no, your lordship,
because the issues of question of framing of issues is totally foreign.
no, because my,
What the issues the court later on framed in that order
Yes.
is actually a point for determination.
so the points of determination will be with respect to adequacy of compensation, my lord. Now, adequacy of compensation can be only proved by way of leading the issues are framed, and in identical case, my lord.
Who
issue-
asked you not to give adduce
my lord,
evidence?
because without leading
You
the,
want now to fill up the lacuna. We are in two
the,
twenty-seven.
the issue is, my lord, twofold, my lord. The issue is twofold. One, my lord, is that there is a pleading, and the learned, if in 8 cases, the learned district judge says that on his own he has framed the issue. On his own he has come to the conclusion. my lord.
Actually, he has used the term wrongly. It should have been points for determination.
So for points of determination, I have no quarrel, my lord.
These are in fact points for determination so that it helps the court to do
To
it.
formulate to answer those points of determination. But when it comes to the issue of deciding the
Let us
adequacy
put
of
this question to you. Okay, let us, although I am not accepting your submission to the
Yes.
effect, let us put the question to you.
Yes,
In terms with order 14, the court can very well issue the frame an issue at the time of delivering of judgment.
yes.
With the prejudice.
So, no, prejudice is, my lord, prejudice is, my lord, prejudice is, my lord, that I did, because I
All
have-
this matter, let us now disperse.
no, you know, what I was saying, my lord.
Or you want another date for argument?
Another day to prove that, another
This
day
is
to,
the third day. after
another
2
day to
years.
show that
There's
CPC
nothing
will
out
apply,
there.
principle of
There is
CPC
nothing
will
out
apply, my
there.
lord. See, principle of CPC.
There is
will-
nothing, Mr. Counsel,
my lord,
nothing. It is a case, although this is
Because if I
environment
can show,
pollution.
my lord, that the land is in use with them even after cutting of the trees, my lord. So when they are determining the compensation, my lord, adequacy of compensation,
No, therefore, the question was, what evidence did you lead?
my lord,
What happened at the time of your cross-examination? What did you do?
yes, my
You
lord.
didn't do anything.
Yes, my lord. What I say, my lord, that
We are
even
in 227.
20 years, my lord, he
exercise
says that I would have used the land for 20 years if the tree was standing on my 12 years, after 8 years, he's using the land, my lord, I'm entitled to.
Because of the fact that when you are assessing the Jirat compensation, even under the Land and Acquisition Act, it is required to take note of the age of the tree and how many years it could have been.
Yes.
That is the basic formula how a compensation is assessed in respect of Jirat.
Yes, my lord. But after the tree is removed, my lord, land is in use to the farmers or not, my lord? If I put a question to, if the land is in use, my lord, therefore because for 8 years he is using the land, he is getting the benefit out of the land. So that benefit, because tree.
No, land is there. Here the payment is only for the trees.
And tree for next 8 years, my lord. That tree will be bearing fruit for next 8 years.
Yeah.
And a tree is removed, my lord. Once tree is removed, land is with the farmer. He is using it for the wheat.
So he
cultivation.
can make another tree.
No, he can use the wheat cultivation. He can use it for other purposes. He's putting the
These are
land. So
not
I
the-
mean, so that is why
Wait.
a issue is required to be framed, my lord.
No, not required.
Because I will not be able to prove that.
Oh, we have the cross also. Let us see what you have asked. I have no evidence in proof that the line.
What I would do, my lord,
Yes.
on next date, my lord, because your lordship has taken a view that it is a.
I am
summary
not taking
proceeding.
a view. My view is always
Oh,
open.
yes, I know.
Your
I
earlier
understand
senior
what I
counsel
did
have
for-
made submissions twice.
Yes.
I am not satisfied.
Yes, my lord.
This is not a fit case for issuance of notice.
Yes, your lordship will.
Are you on caveat?
Received notice.
Oh,
Item
fantastic.
number-
What is your submission? Let us hear you.
My lord, only submission that I can place, my lord. First of all, in civil division 36/25, my lord, I filed an IA. The respondent expired and the wife has come as a substitution. That IA, my lord, your lordship will dispose of. And my lord, on the basis of my submissions, my lord, one issue that I should clearly submit to your lordship. Taking into section 23(2), the division bench in the similar case, my lord, while dealing with the interest, Justice Ranjan Gogoi and my lord, Rishikesh Roy has said that the interest will, or the solitium of the interest will not be applicable to the persons who are aggrieved. But as regard compensation, because during that time, there was a division bench, there was an appeal against 227. So there was a division bench judgment, that is, my lord. para
What
6
happened?
Para 6 onwards, my lord.
What do you say?
Then that was the argument, and then it was decided in subsequent paragraph. And para 12, my lord, your lordship has, they have hold, the division bench has hold. Deciding on a Supreme. Court-
Here, solatium has been granted.
My lord, here interest has been granted as.
Mr. Counsel,
That is different, my lord. Solicitor-
are you engaged by the petitioner?
No, no, my lord.
Then what are you making that submission?
My lord,
You see, this is on the basis of Sundar judgment.
my lord, on the basis of that.
I was not aware of this constitution bench judgment.
My lord, my lord.
Then, on the question of solatium, interest on solatium out there. That was the question at that point of time. But then also it was held that it is permissible. This was a judgment given in 2010. Then
My lord.
first look into the judgments and then make submissions
Well,
before this court.
My lord, and balance, my lord, I rely on your lordship.
Mr. Roy Chaudhary, you come this side.
My lord, rely on,
This side.
my lord, rely on,
No, Mr. Roy Chaudhary, you come this side. You're not fit to be on this side.
because I thought that it will be a fair.
Absolutely no. That judgment has no,
This is, I
nothing to
rely on
do.
this judgment of your lordship.
What is this? This is on limitation.
The limitation and my lord, regarding compensation, everything has been discussed by your
No,
lord.
no, I have not dealt with the compensation amount. This is the first case on compensation where as to whether issues is required to be framed or not.
My lord.
The counsel out here, the senior counsel out here for petitioner says that look here, the Supreme Court uses a word out there in a suit
My lord.
in one of the judgments.
In
So
2017.
we are to read it as, there is a word also used by Supreme Court, na? That elucid theorem, that don't read the judgments of the Supreme Court or even the High Courts as a statute. So he wants that I should read it as a statute.
As I've heard of from your, that what I have heard of your lordship.
Different manner, I would.
You see, using a word in a suit, tomorrow the Supreme Court says, that, okay, he file, let him file a suit out there in the, as per that.
No, what
What you
I've
call,
heard of from your lordship.
Land Acquisition Act, a suit has to be filed. So now we are to frame issue.
My lord,
That, to that extent, I can't go. my lord.
my lord, here,
I-
their
what-
repetition
my-
was
No,
fine.
Mr. Counsel, why I say so?
Yes, sir.
Why the question of issues does not arise? Let us take the example of a land acquisition case. A land acquisition case can be filed only on 4 issues. For inadequacy of compensation, apportionment, entitlement, as well as the area.
Yes.
Okay? Now, within the period time permitted, if you don't do so, the court cannot, whether they are pleadings or not, frame the second issue. The law is very clear on
Yes.
that.
Absolutely. What I was pleading, my lord, that the CPC, the principles of CPC, because ultimately principles of CPC are principles of natural justice.
Only power which can be given to this court is under 151, taking into account the recent judgment of the Supreme Court in Gayatri Balasamy, where the Supreme Court says that even a court of limited jurisdiction under 34
Yes.
would also have the inherent power under 151,
Yes.
not Order 6, Rule 7, Order 14, Rule 4, Order 14, Rule 1, nothing to that effect.
Yes, my lord, I would request one date, my lord, so that I can deal and do some more research on this aspect. But my
Please.
submission is, my
Please.
submission is, my
First
lord,
and foremost, Mr. Counsel, a dispute will only arise when you say that there was a dispute which a particular dispute has a reason. You cannot say that making of payment is a dispute.
yes,
You have to categorically mention that the dispute arose on such and such date, and from there 3 years have gone by, then also they have not filed.
Yes.
Yes, then it's a case of limitation.
now see, my submission is, my lord, that so far as case of limitation is concerned, 16(3) uses the expression compensation to be paid and not actual compensation to be paid. Determination, statutory determination under section 10, subsection D of the Telegraph Act. Once I did the determination, the cause of action in my humble submission has arisen, because that was the judgment which was interpreted by the Honorable Supreme Court in Kerala judgment of 1973. When in the context of Telegraph Act only, my lord, that judgment is
That
also.
I read it. You have
You-
given it here.
Yes, your lordship.
That,
kindly see.
the Supreme Court only says
Page
that
46.
137 will apply.
Yes. your
But
lordship,
there
yes,
further, the Supreme Court says only on the basis of a dispute.
So,
So the question is, you cannot say that the day on which you adjudge the compensation, the dispute arises. No, you have the tender. He has to be known that this is the amount on any, and he has disputed to that. What is the meaning of a dispute?
so the
Making of payment does not amount to a dispute.
the making of payment does not amount to dispute, my lord. What amounts to dispute in my humble submission, my lord?
Then did the Power Grid go to Supreme Court against that judgment where I have held the dispute cannot arise like this. The dispute has to arise only when you raise the.
Yes, my lord. Your lordships have taken a view in that matter, my lord. But there are 4 submissions which I have, my lord, before your lordship. One is with regard to limitation in various cases, my lord. So your lordships have taken a view, because in that very judgment, that dispute arises when there is the denial that this amount is not adequate, and therefore the dispute has arisen. My lord, I put a question to myself that I have tendered the amount to the plaintiff on X date. After 5 years, he raises the dispute.
So therefore you are to give evidence to that effect that he has received it without protest.
Now, so in this case, my lord, there is no material whatsoever to show on the plaintiff.
Mr.
that-
Counsel, pleading is not proof. That is
Yes.
also well settled
Yes, my
now
lord.
as
Yes.
you want the CPC to be involved.
Yes, my lord, pleadings are not proof, but at least
Not
in
one,
the
many
pleading, at
judgments
least
are
it
there.
should be there. It should be there that on the date when I received.
Next time in this compilation, you get the judgment of Union of India versus Ibrahimuddin, where it is categorically mentioned the pleading is not proof.
Yes, my lord, that pleading is not, but pleading is required, my lord. If I take your lordship to the recent judgment of the Honorable Supreme Court in the compilation only, my lord, 2025 judgment, my lord, on this issue of Justice Pardiwala and Justice,
Yeah, where?
that judgment, my lord, is 2025. Which page? 107, my lord.
Page?
Page 107 and paragraph 19 at page 122.
This is, you are referring to The judgment, the recent judgment on order 7, rule 6 has to
Yes.
be mentioned.
Yes,
But
ma'am.
that is the mandate as per the CPC. That is why the
Yes,
Supreme
your
Court
lordship,
mentioned. Now, are you now trying to say that the application under section the 16C
I
has
have
to be drafted like a
labor
suit?
must labor on this point, my lord. So, lordship may have it on, after 2 weeks, my lord.
So this
after
means-
I will lordship, I will try to, that CPC is applicable unless it is specifically not excluded, my lord. That is also a principle. CPC exclusion is, is not readily enforced.
Show
my lord.
me that CPC is applicable
Yes.
even in a case of limited jurisdiction. We are concerned. My specific query to you, let us not say anything else, other aspect is not there. Next time you want to try to satisfy this court. In a case where it is a limited jurisdiction, just for example, this one or 34 or all this thing, can you bring the principles of CPC? That's you answer that, then you can get a notice from this court.
Yes. I will try.
That to subject to deposit of the entire amount. When do you want? With interest.
Can I pay that I maybe?
30th May, your lordship.
You have made a very bad submission, not today.
30th May, 30th May, your lordship, subject to your lordship.
And
30th May.
okay, 30th of May. Yes, I এখন দিয়কচোন কিবা এখন I এখন পাই
1470.
You filed an IA there to be substituted.
Substituted because my husband expired.
So they have filed it against the dead person.
Item 36.
So why should you should only inform.
Yeah, yes. Lordship, that, my friend, now there is some changes in the CPC also, my lord, which requires the respondent to inform the.
That is brought by this recent judgment in Om Prakash Sharma. By Justice Dipankar Gupta. This is an application filed by heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the applicant, and Mr. So-and-so, who appears on behalf of the respondent, opposite party, who are the writ petitioners in, who are the petitioners in CRP 36 of 2025. The learned counsel appearing on behalf of the applicant submits that the respondent against whom the instant proceedings have been filed, the accompanying proceedings have filed, had expired on 7/11/2024, leaving behind the applicant
Why?
as his legal representative. Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the applicant submits that in terms with the recent judgment of the Supreme Court in the case of Om Prakash Sharma versus so-and-so, I think it's a citation to the report recently the judgment, comma. An application under Order 22, Rule 3, or Rule 4, can be filed by either of the parties to this proceedings, and as such, the instant application has been filed. The counsel appearing on behalf of the opposite parties oblique the applicant, the petitioners in the accompanying petition submits that he has no objection to the said application. So taking into account the above, this court substitutes the respondent number number 3 in the accompanying proceedings and with the applicant and arrays him as applicant number 3 respondent number 3.1 in the accompanying proceedings. the council appearing on behalf of the petitioner in the accompanying petition is directed to file a fresh memo of parties before the registry of this court within 3 days. And on the basis of that, the registry shall make necessary changes in the cause title and update the same in the CIS. I stands disposed. Egon main bitat lekho. Mr. So-and-so, the learned senior counsel assisted by so-and-so submits that some more time is required in the matter. He requests for further time to answer the query as to whether in a proceedings with limited jurisdiction, the provisions of all the provisions of CPC would be applicable on Code of Civil Procedure of 1908 would be applicable. So taking into account the above, matter is fixed, all these matters are fixed on 30th of May 2025 for further hearing.
In some of the matters, interim orders are continuing till next date, my lord. If interim orders are continuing, my lord.
I cannot,
Item 9.
my conscience does not permit.
Item 62, 63, 64, the supply list, same orders.
I can take these matters along with that. Will you go? 63, will you take these matters? Mr. Counsel, you have been, these orders were passed long time back. These orders were passed.
30th April.
Hmm?
30th April.
Passed these orders. It will be case at the
25th March. my lord. Your lordship is not-
The challenge to the orders passed on 12th of April 2023 is being done in the year 2025. And you want the state to extend? Oh, also answer
In
the.
4 matters, my lord, the stay has continuing, my lord, 4 matters. In 4 matters, in all, their stay has already been granted.
No, there's on delay. I'm not concerned. I'm not.
Item 9.
You have not paid all this while. Nothing has happened. These poor people, they have
raised
not
the
filed
demand
anything.
matter and
Only
the-
thing, only consideration for issuing notice in these matters is asking you to deposit. Once you deposit, I can ask them to take the money and then dismiss your petition. Nothing. more than
My lord, I am sorry to.
Demand notices have been issued only 1 week, my lord, 10 days, your lordship, the stay is continuing in those matters, at least 4 of the matters. my lord.
I'm not going to. I'm not. In fact, that is why I brought in out there. Should I pass an order that I'm not inclined? Better not, no?
My lord,
You can very well show it before that executing court. They'll look here. The court has passed an order. He is looking into it, so nothing is there. I think that is a better.
my lord, can I?
give all the names for all the matters again.
No, they will, all these matters have come, no? But, Mr. Counsel, 30th is the last date, huh? Either I issue notice
Yes, my lord.
and I'm telling you, issuance of notice is subject to deposit of the entire amount along with interest and not dismissed.
My lord,
Only submission, my lord, is that your lordship has said that it is a case of limited jurisdiction.
Limited.
Yes, your lordship has.
My
uh,
question
it
is very
framed-
simple.
Your lordship has framed, what I was praying, my lord, that permit me to persuade your lordship that it is not, this is a limited jurisdiction, but in a sense where
No,
issue-
that is why I'm saying, if it is in a proceedings of limited jurisdiction, can you bring in CPC?
Yes.
That is the question
Yes,
I've asked you.
That-
That is what in a case, because the fact is that these courts are having limited jurisdiction. 34 or the 16(3), these are all limited jurisdiction. Now,
Arbitration Act is concerned, the law has said that CPC and Evidence Act may not necessarily be applicable. So far as there is no such provision so far as the Telegraph Act is concerned, Lord. I'll try to persuade your lordship on
So
30.
therefore, I'm not saying 34. Here, I'm only giving you an analogy of 34.
Grateful, grateful.
Yes, who is this? Who is appearing in item number?
9.
9. You're challenging.
My lord, before start of my lord, learned criminal may have subpoenaed my lord. I have instruction to appear on behalf of respondent.
Very well, appear. Now, what are you challenging?
Actually, I'm challenging the order. Order dated 18 January 2025, which has been passed in a petition requiring the summoning of official witness in a probate case. Please come to the operative para of the order, case 34, last para.
And order 16 is the summoning of witness, order 16 is within provides that the court
May I read out?
Someone, any person who has not been. So notary is not required. That is said.
Yes.
Then,
My issue is not,
did you give it in the list of witnesses?
no, it was not in the list of witnesses. So when I have done the cross-examination of the other witnesses, PW1 to PW3, so there was veracity in the statements made by them. So then I. thought
No,
that-
tell me one thing. This document was notarized
This document was notarized,
by,
Notary Public, Jyoti Kalita.
he is not a witness?
He
Is he a witness?
is not a witness to, in the will.
As per the, for the purpose of the will, what is required? You are paying for whom?
Respondent.
So
In
you
the-
are for the
opposite
respondent, huh?
Opposite party in the case.
So you are challenging the will. You're challenging the will. How is it relevant?
It is relevant because, Your Honor, during cross-examination of PW1 to PW3, there were veracity in the statements made by them.
So very good, you should be happy.
I should be happy. I want to make it more stronger.
Right.
I want to make my.
Don't make it stronger by making unnecessary persons out there.
May I take you to
We are concerned with a will. A will can be on any piece of paper. How is it relevant? That it is, yes, if it is registered and in,
Whether-
in terms
whether
of this section
present-
40, subsequently, it's a different aspect of the matter.
it's present or not present?
How is it relevant? In a will, how is it relevant that we were in a notary, whether he was present or not? There is no business out there. The fact that that person has executed it and it has not been executed or yes, has been executed has to be proved only by those two attesting witnesses. Isn't it? Nobody else can prove that. So these, I think, will be the witnesses for the plaintiff, for the person who has filed a suit for probate. So you have a right to cross-examine. Why you are spoiling your case with this notary? I would have understood he asking. Why you are spoiling your case? The moment the witness comes, the notary comes and says this, yes, he has done it in my presence. Are you not spoiling your case?
No, Your Honor.
Why?
Because the statements of all the three PWs are different.
So that is why you
I also
already
think-
have it. So why do you want an evidence against you?
May I take you to where the will is case number 23?
And have you given this? No. First of all, did you give the name of the witness of
No.
the year? No. Then
After
63.
questioning the PW1,
No.
PW3,
No ground. No ground, no ground. Just a second.
may I take your lordship to case number 24?
Not necessary. Let me not give you any opinion on this. And you want the court to exercise the powers under order 16 and 14.
No, no. For someone in the official witness.
Therefore, dismiss, withdraw, which one? Either of it. Withdraw. Learned counsel appearing on behalf of the petitioner submits that he would not like to press the instant petition. He, however, submits that non-pressing of the instant petition should not prejudice him before in proceedings being PTS number 04/2023. Taking into account the above, the instant proceeding stands closed on withdrawal. It is observed that the withdrawal of the instant petition shall not prejudice the petitioner in PTS number 04/2023 pending before the learned district judge. Aminga.
10,
Not on caveat.
Areas are expired, madam. Though KBA has been logged, madam, but areas are expired.
Lordship, matter kindly pass over for time.
What?
Pass over for the timing.
What are you directed to take steps and the ER will insert the necessary paragraph in. What are you challenging?
Order dated,
Amendment allowed.
yes, Lordship,
Why are you challenging?
because the amendment petition has not been allowed by the.
Huh?
Amendment petition, which has been filed by the plaintiff, it has been rejected by the court below, your lord.
Are you sure?
Yes, Lordship.
Where is the amendment?
Lordship, amendment petition, we have annex 2, your lordship. At page 16, your lordship.
Who is your senior?
Hardek, Mr.
You want it dismissed in his hands or whose hands?
Nogao, civil.
Huh?
Nogao civil just junior division
No,
number.
no, in whose hands do you want it dismissed? In your hand or your senior's hand?
Senior.
Senior, okay. We dismiss it by 12:10.
Lordship, you fix another, your lordship.
No, no, no,
And
no.
then,
This court cannot.
okay, lordship.
You were dispossessed during the pendency.
Yes, there is
Huh?
a prayer for ST, your.
filed in 2010
Yes, Lord.
and the sale deed was happened in 2006.
Yes.
You did not challenge the sale deed.
No. We have
In the
filed-
written statement filed, they mentioned about the sale deed.
said
There was a
that is
wrong
defined
mentioning.
Defined sell date.
Number is wrong. Date is same.
Sell date executed in respect of defendant number 124, Your Lordship.
Ah.
The 3 bigger 5 kata 1 lesser land has been sold to defendant number 124.
Then
That sell date has been,
where's your plaint? No plaint.
no,
Why haven't you enclosed? How is it possible? How will I look into? You have to bring in on record the plaint, written statement, everything. Why haven't you brought it?
written objection and our
Mr. Counsel, what amendment do you want?
amendment petition, Lordship, basically we have to.
For amending what? Amending the plaint.
Yes, Lordship.
Then the plaint is not before this court. Then? When was the order passed? Amendment happened, why? 2/9/2024. When did you file this?
25 February, 4th February of 2025.
Huh?
4th February of 2025.
Then, after 5 months, why?
Because some delay has been occurred due to obtaining the certificate copy
Of,
of the document, Your Lordship.
when did you apply?
Apply on 28/11/2024.
Then,
And then we have received this 1/2/2025.
1/2, because of the fact that you did not do the next thing.
Yes,
You did
Lordship.
it on 10/1,
10/1 we have
deposited,
knowledge, yes, Lordship.
and therefore you
then-
have got it then on 10/10. What is 10/10/1?
10/1 we have submitted the case.
And then it had happened on 1/2.
1/2 we have they informed the copy has been ready, and then
So-
on the same day we have received.
So, then why haven't you, this is completely delayed if you had not. Oh, no case. Hello, let me dismiss it. Heard, Mister, I dismiss it in your hands.
Lordship, my Uddhav,
No, huh?
allow me, Uddhav. I may allow to.
Withdraw. Okay, Mr. So-and-so, this is an application filed under Article 227 of the Constitution challenging the order dated 2/9/2024 passed in title suit number 35/2010, whereby the application filed under Order 6 Rule 17 by the plaintiff being petition number 1965/2023 was rejected. The learned counsel appearing on behalf of the petitioner submits that he would like to withdraw the instant
With
petition.
liberty, with liberty,
What liberty?
because we.
No case. Where's your due diligence? What
We
due
may file,
diligence?
along with the.
Where's your
pelleting
due diligence? We are at the stage of defendant evidence. You give your evidence, now you want to again give evidence.
Lordship, actually, in the suit plan, the youngest counsel of the court below has not mentioned the boundaries. If the boundary is not mentioned in the plan, it would be difficult to decide the case also, Your Lordship. And therefore, we file the amendment petition under under Order 6, Rule 17 for amending the plan.
No, you are not asking some other amendments are also
No,
being sought.
Lordship. No,
Yes,
no, Lordship, regarding boundary, we have.
your petition.
If your lordship will find at page 10, your lordship. We have.
What is
mentioned-
the amendments you are asking for? Page 18, kindly come. In the title portion of the plaint, after the names of the addresses of the defendant number, new names are to be added. From the written statement filed by so-and-so, so-and-so, it has been wrongful gain and so-and-so, so-and-so, so-and-so. This is paragraph 5 you want to insert. In line number 2, prayer portion so-and-so, a suit, a decree for delivery of khas possession in so-and-so. in line number 2 of the schedule, after Nagaon be added, which is bounded by so and so. So,
Propose amendment in plain. Propose to amend the plain, your lordship. This is-
all others are not permissible. We can only have only on 20, nothing more than that.
Lordship can allow one more days. I may prepare properly, your lordship.
Huh?
I may allow to more, 1 day for preparing properly, your lordship. Kindly give it.
Okay. And Mr. So and so, the learned SI and the learned counsel appearing on behalf of the petitioner submits that taking into account the taking into account that neither the plaintiff nor the written statement have been enclosed to the instant petition, he may be permitted to withdraw the instant application with the liberty to refile. Full stop. This court has duly taken challenge made to the order dated 2/9/2023.
Four.
24. This court have duly taken note of that by the instant proceedings under Article 227, a challenge is made to the order dated 2/9/2024 entitled suit number 35/2010. Full stop. This- Taking into account the above, the liberty is given to the petitioner to file a fresh petition within 7 days from today, failing which there shall be no liberty. Full stop. It is further observed that filing of a petition before this court would not amount to any stay to the proceedings before the trial court.
Problem.
Item 11.
Withdrawal permitted, subject to liberty given to file within 7 days. Next.
May I please, Lord?
Ah.
My lord, this is my lord, against the allowing of condemnation, this challenge, my lord. Eventually, I was the defendant in the title suit, number 94, 2020. And the title suit was dismissed for default. That is, my lord, page 38. That is 31, 2024, dismissed for default. And thereafter, my lord, plaintiff filed a petition under order 9, rule 9. Along with the condemnation petition for delay of 96 days. But the cause of delay has not been propounded properly. Even though, my lord, that condemnation petition has been allowed. And the injunction petition rejected here clearly appeared that it is a meritless case, my lord. Because the specific performance of contract on the basis of, my lord, one unregistered sale deed and which was written on 5 rupees stamp paper by consideration amount of 15 lakhs. And that
Delay of 96 days have been allowed, against that you are filing.
but that was not propounded properly. Lordship, kindly have a look the condemnation petition. Condemnation petition, page 39. Here, my lord, issue long period or short period not involved, my lord. Question is whether delay, cause of delay shown insufficient or sufficient. This is insufficient cause of delay, my lord. Here, my lord, page 40, saying that paragraph 2, because the suit slipped in his mind, hence the suit
And
was
was it dismissed at the stage of SBPH?
SBPS.
That is not the stage of hearing. How can the court dismiss it?
But on subsequently.
No,
two-
how can a court dismiss it? Only see order 9, rule 8. The court can dismiss it only on a date which is fixed for hearing. Dismissal was wrong, rightly done. 96 days, Mr. Bhuiyan.
But question is, my lord,
No, Mr.
when, my lord,
Mr. Bhuya,
I
first
relied
of
upon-
all, if there is no limitation, 137 will apply. They can very well come under 137. Because there is a judgment of Justice Vaipaya also.
but, my lord, recent judgment, Moul Chandra saying that cause of delay should be.
There's no delay. There's no delay.
that may
First
be-
of all,
that may be
no,
one-
no, Mr. Bhuya, tell me, can a suit be dismissed on a date which is not fixed for hearing? My only question is that.
But, because of.
He has done
because
it
of default-
wrongly.
Because of default, if the party file a suit, if not interesting.
This petition will be a petition under 151.
On that ground, because of default. If found default, court cannot continue the proceeding. That is why dismiss for default. This is for dismiss for default. At
No,
any stage, at any stage.
Can the
found-
court,
Found absent.
no, Mr. Bhuyan, kindly see Order 9, Rule 9 and Order 9, Rule 8. Order 9, Rule 8 says when the plaintiff doesn't appear and the defendant appears, then in that case, the court shall dismiss the hear if it is fixed for hearing. Here, the suit was never fixed for hearing. What is the steps before plaintiff preemptory hearing? Cannot be, that steps before preemptory hearing.
But the condemnation petition doesn't say such.
I'm not concerned.
Condemnation
The
petition-
entire proceedings is wrong. The court should allow him to participate.
Condemnation petition only saying that you are slipped in his mind.
Which one?
And
Dismiss.
so-
Withdraw. Which one? Which one? Dismiss,
My
withdraw.
question is, if I withdraw, again, I may face trouble.
Heard
Because
Mr.
Without
K.
consent.
Bhuya, the learned counsel appearing on behalf of the
Notice
petitioner.
may go, my lord.
Huh?
Notice may go.
No, 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 no.
Because, my
Notice
lord,
means stay. Notice means stay. Don't you think so?
But, this,
No, it's okay.
this judgment, my lord,
yeah.
if dismissed, my lord, this judgment will follow, my lord. Paragraph 14. In the same case, my lord, says regarding condemnation of delay, it also has to be taken into account the merit of the case. And here, my lord, the title should file on the basis of fact and fabricating document. And regarding 15 lakh rupees. And it was prepared on 10 rupees stamp paper. And therefore, my lord, this injunction petition has been rejected. That is, my lord, page 32, dated 10/11/2020. Very clearly narrated. That is a meritless case because stamp paper only 5 rupees. They have retained this huge amount of consideration. So meritless case.
I am now allowing his petition even under Order 9, Rule 9. I'm allowing that petition also. That was also not necessary. He should be allowed because it was dismissed wrongly. I set aside this order of 31/2024. You couldn't have dismissed if the suit was not fixed for hearing. Heard Mr. K. Bhuya, the learned counsel appearing on behalf of the petitioner. To stop. The supervisory jurisdiction of this court has been invoked, challenging the order dated 13/3/2025, passed in Mize case number 89/2024, whereby the learned court of the civil judge, senior division Borpeta, hereinafter for short referred to as the learned trial court, had in exercise of its discretion condoned the delay of 96 days in preferring the application under Order 9, Rule 9 of the Code of Civil Procedure 1908. For restoration of the suit, which was dismissed for default on 31/2024. Full stop. This court have duly taken note of the provisions of Order 9, Rule 9. Full stop. This court have duly taken note of the said order passed by the learned trial court. And taking into account the fact that the learned trial court had exercised this discretion, this court would not like to exercise its supervisory jurisdiction as this court did not find any perversity or anything shocking. Full stop. Be that as it may, this court further finds it relevant to observe that on 30/1/2024, the learned trial court had dismissed the suit of the plaintiff. Full stop. Against which the application has been filed under Order 9, Rule 9, along with an application for condonation of delay. Full stop. This court is surprised to take note of that the learned trial court, by the order dated 30/1/2024, had dismissed the suit for default, that too when the suit was not fixed for hearing, not called on for hearing. Full stop. This court duly takes note of the provisions of Order 9, Rule 8, wherein the power is being conferred upon the court to dismiss a suit only when the suit is called on for hearing. Full stop. It is seen from the very records, from the very impugned order, that the suit was fixed for SBPH. Full stop. And there was no hearing, no date of hearing, and the suit have not reached the stage of hearing. Considering the above, this court therefore is not inclined to interfere with the said order. And further, this court directs the learned trial court to take the application filed under Order 9, Rule 9 as an application under 151 of the code and restore the suit to the file of the court, taking into account that it was a mistake committed by the learned trial court in dismissing the suit for default on a date which was not fixed for hearing. I allowed two applications.
I have one judgment, may it note,
Not necessary. All judgments are for Supreme Court.
because it is a totally meritless case.
Merit, I am not concerned. First of all, Mr. Bhuya, kindly understand one thing. The
That's
suit
right.
could not have been dismissed for default on a day which is not fixed for hearing. It could not have been. And this exercise of the power under Order 9, Rule 9 is not conceived of. So it should have been an application filed under 151. And 151, the limitation is under 137, which is 3 years, as per the judgment of Justice Vaipai. This is the facts.
Your Lordship. Lordship, the petitioners are the defendants in a commercial suit. Earlier, the suit was filed before the court of the Munsif, my lord, as a money suit, my lord. Thereafter, it was transferred to the commercial court. And my lord, on receipt of the notice, my lord, we have filed an application seeking certain documents which have been annexed with the plaintiff, my lord, as that were not furnished to me. So on 26/9, that petition was filed, and my lord, they have given me, submitted those documents on 30/5/2024 before the court. 30 May, 30/05/2024.
30 May.
Yes.
Okay, then.
Then, my lord, on the next date, my lord, on 15/7/2024, my lord, we have received that documents from court, my lord. And my
No,
lord.
no. The time will start from 35. Then
Yes. Yes, time will, if we, 30, then my lord, court has fixed the date for filing WS on 19/9/2024. And on that day, my lord, defendants, my lord, we have defaulted in appearing on behalf of the defendant. And then, my lord, the court has fixed the date for on 29/11/2024 for ex parte evidence.
So 39/2024, 120 days is over.
No, I am within that 120 days now.
How?
My lord, from on 19/9/2024, my lord, when the court, my lord, proceeded ex parte, my lord, I was within the 120 days, my lord. So, my lord, thereafter, on the very next day, my lord, on 29/11, my lord, I have submitted my written statement, and
29/11 is beyond 120 days.
29/11 is beyond 120 days, my lord, that I admit, my lord. But, my lord, on 19/9/2024, my lord,
Then it was not.
then it was not. So, my lord, I have filed an application under Order 9, Rule 7 for setting aside the ex parte order of proceeding ex parte. And, my lord, also I pray for acceptance of my written statement.
Order 9/7 does not arise. Court may pass an order that we are proceeding ex parte against him. You will be permitted to cross-examine, do everything. But you had to file within 39. But you filed it on 29/11.
Because, my lord, in between that, my lord, there was no date fixed, my lord.
Not necessary. Can't help it. Now, can the court permit you to take the written statement which was filed on 29/11?
My lord, my submission is that, my lord. As, my lord, the court has already, my lord, set aside that part, my lord, ex parte order, my lord, and allow my petition under Order 9, Rule 7, my lord. That means, my lord, I relegated back to the earlier position, my lord, when the date was fixed for filing my WS, my lord.
You should have filed your written statement within time.
But, my lord, when the
And your petition does not say a single word of the.
What?
The court says,
yes,
court does not say, the question of proceeding ex parte is completely foreign in CPC. That, okay, we won't allow the defendant to appear any further. No. Order 9/7 only says that to bring the suit to the date on which you did not appear and what has happened, you have to show good cause.
yes.
Okay. Otherwise, the law as far back as in 1955 Sangram Singh is clear that you will be allowed to participate in the suit proceedings.
Yes, yes.
Very well. There's no quarrel with that proposition. So the court out here by the impugn order say that yes, you will be allowed to participate. But for you to accept the written statement does not arise, taking into account that 120 days is over. Now, in your petition, which is filed under Order 9/7,
Yes.
you don't put anything mentioned out there. You have taken it as if like it is a simple civil suit.
No, my lord, I have stated, my lord, why
No,
I have.
kindly
I-
see paragraph page 38. I'm reading that petition only. Where
Yes.
did you have mentioned that on which date you have received a copy of the summons? Then where do you have, and from where it will be 120 days will be there? The court is right in passing that order.
My lord, I have not mentioned it, but my lord may kindly see, my lord, the order dated, my lord, 15/7.
I'm not going
There,
to
my
look
lord,
into this.
I
This
have-
is
I
not a
have-
part of your petition.
I have clearly mentioned, my lord,
No,
that
then
I have received.
show
the
me where you
documents on-
have mentioned in page 38 and 39.
My lord, on page 38 and 39,
This
my
is
lord.
your petition.
Yes, yes.
This is the petition on which that order is being passed. And how do I find that there is any cause for which I should interfere, exercise 227? This is not a case, because the, the provision of order 8, rule 1 categorically mentions that in a suit for commercial suit, the question of going 120 days beyond is not permissible. You should have filed it on 3011, 3010, 39. You should not. You didn't. Then where is the question of accepting?
But my lord, when my lord, my petition was allowed, then automatically, my lord, I relegated back to the earlier date, my lord. On that
Petition was
particular
not
date, my-
allowed. That you will only kindly see the language used by the learned trial court.
Yes.
Kindly see, upon hearing and perusal, it appears to me that the instance is the commercial suit which is to be proceeded in an expeditious manner. It is mandatory to file the written statement within 120 days. In the instant case, if the defendant is allowed to participate in the suit, it would be held in the adjudication of the matter. Accordingly, considering the above, the prayer of the defendant is allowed and set aside. The order dated 19/9/2024. However, the written statement filed by the defendant is not accepted, but the written statement is defendant is allowed to participate. Then, because you
Well,
filed it on 29/11.
My lord, unless, my lord, my WS is on record, my lord, I'll be prejudiced, my lord.
Can't help it.
But my lord,
Supreme Court can only help it.
my lord, Supreme Court, my lord, I have, my lord, gone through a judgment of Honorable Supreme Court. my lord.
Tony,
There, my lord, 120 days have been, my lord, discussed, my lord. In that case, judgment, my lord.
in a commercial matter. If the Supreme Court has done it very
No,
well,
no, my
I'll
lord.
help you out.
Supreme Court has, my lord, in that particular case, my lord. In that particular case, what had happened, my lord, 120, my lord, within that 120 days, my lord, the written statement was not filed.
Forfeit the right to file written statement, and the court shall not allow the written statement to be taken on.
Yes, but my lord, in that particular case, my lord, they have, instead of filing the written statement, they have filed an rejection of claim. And rejection of claim was, my lord, when my lord rejected, then they have make an application for granting 7 more days time to file their written statement. That was, my lord, rejected by, and saying that 120 days within, within 120 days, my lord, it will, but my lord, this case is not, my lord, applicable in my case. Because, my lord,
The provision is applicable, forget about this.
but my lord, here in this particular suit, my lord, apparently, my lord, the suit is, my lord, my lord, limitation, there is no limitation. Out of, my lord, limitation, my lord, this suit was filed, my
So
lord.
argue that, it's a
my-
point of law.
And my lord, also, my lord, there was a settlement, oral settlement, and we have
Bring
paid
it.
the entire amount, my lord. Then, my lord,
Bring it before the court by way of evidence. Recently, another judgment after following the judgment in the case of modular mills, 1988, there is another recent also judgment says that you can cross-examine only to that extent. Right? It can't help you with this order. Mr.
give me a short accommodation, my lord. I just want to myself little bit more,
Eh?
if possible, my lord,
Mr. M. Datta,
yes.
the learned counsel submits that he requires a further accommodation to look into the law in this regard. List this matter. When do you want the dismissal? Get us the date. The date might
Lord,
not be
after
good today. 16, bad date. 21st, good date.
Yes, ma'am. Obliged.
List the matter on 21/5/2000.
Item 13,
Case lordship,
We have challenged an order, impugn order dated 10/3/2025, passed by the learned civil judge, senior division at Hailagandi, my lord, arising out from a money suit where the petitioner is the defendant therein, whereby the learned court had rejected a petition for recalling its order dated 1/8/2024, wherein the cross-examination of the plaintiff witnesses were dispensed.
The state, 25,000 will be the cost.
Should be first,
Get your thing ready with that, 25,000 in the mean.
yes,
We stay subject to 25,000.
yes, yes.
Because your case is that on that day, your counsel sought for an adjournment that was rejected and the court fixed the matter for defendant
Yes,
evidence.
Yes, yes,
You want the recall of that order.
yes, we on the
But
recall.
I also look into it that there has been various costs being imposed upon the counsel, upon the defendant for not cross-examining the witness.
Yes.
So today I'm thinking 25, it may go to 35 also on that. Very soon. 7-4, what happened on 7-4?
7/4 lordship, since the matter was fixed for defendant witnesses, we sought for an adjournment and it's fixed on 25, this is on next Tuesday, lordship, at Hailagandi, lordship.
Issue notice making it returnable on 26th of May, 2025. Stop. Steps be taken upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Stop. The petitioner herein have assailed the order dated 10/3/2025, passed in money suit number 1/2021 by the Court of the Learned Civil Judge Hailakandi, whereby the petitioner, by an order dated 1/8/2024, whereby the application filed for recalling of the order dated 1/8/2024 was rejected. Stop. This court have duly taken note of the submission made by the learned counsel appearing on behalf of the petitioner, that it was a fault on the part of the counsel who appeared on behalf of the defendant, who did not cross-examine. And it is under such circumstances, the defendant ought not to have been penalized by the court. So taking into account the above, this court stays the further proceedings of title money suit number 1/2021 pending before the court of the civil judge Hailagandi till the next date. You don't take your service,
Will take well,
and then dusty hekin likhi dibo na, dusty routed through this.
obliged.
Supplementary item 59.
Lordship, I pray for Passover for the time being senior counsel is appearing. She was there, she's appearing on the night. She'll be here, madam.
Number 2.
Yes, madam. I'm not seeking time, madam. For the time being, madam.
What are you challenging?
My lord, I am challenging the impugn order annexure 14, my lord.
By which?
My lord, page 199, my lord. Actually, what
One-
happened, I, as the plaintiff, had filed a suit, my lord, in the trial court, seeking for damages, compensation, and permanent injunction, my lord.
You are the
However-
plaintiff.
Yes, plaintiff petition.
And
After, my lord,
Lordship, from this slide, Lordship, we have challenged, my lord, the order dated 29/4/2025. Page 199, your lordship.
Why are you before in CRPIO? Why?
Lordship, because your lordship, section 8, the mandatory provisions, as envisaged in section 8 of the Arbitration and Conciliation Act has, is not followed, and learned trial court in violation of the past impugn order.
So you have challenged an order by which an application under section 8 was allowed.
Yes.
Okay.
My lord.
Why are you under 227? Have you at all gone into and seen the Arbitration and Conciliation Act? Have you looked into what is section 37 or just right away filed the petition?
37, may I have a look? my lord?
37 1A.
It's a appealable order.
What is it?
37, 1A.
Yes.
Refusing to refer the parties to arbitration under section 8, or notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders to the court authorized by law to hear appeals from original decrees of the court passing the order, namely, refusing to refer the parties to arbitration under section, in our case, it is allowed, your lordship. Granting or refusing to grant any measure under section 9, it's not it's applicable in our case. Setting aside or refusing to set aside an arbitral award. Lordship, probably CRP will lie, my lord. Lordship, I don't have so much of knowledge, but from a limited knowledge, my lord. Because in our case, reference was allowed, your lordship. Violating the provisions of section 8, 1.
So by which now the application has been allowed.
Yes, your lordship, may kindly have a look at 8.1, provision as envisaged in section 8.1.
What does it say?
A judicial power to refer parties to arbitration when there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of, lordship may kindly note that part, not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds the prima facie no valid arbitration agreement exists. In our case, your lordship, before this application was moved, they have preferred written statement, your lordship, and they have not filed any statement application, my lord, annexing the original document, which is envisaged in section 8.2, my lord. The application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. Provided that where the original arbitration agreement or certified copy thereof is not available, with a party applying for reference or arbitration under subsection 1, and the said agreement or certified copy is retained by the other party to that agreement, then the party so applying shall file his application along with a copy of the arbitration agreement and a petition praying the court to call upon the other party to produce the original arbitration agreement or duly certified copy before the court. Notwithstanding that, an application has been made, so and so, lordship may not be applicable in our case. Lordship, they have not taken the plea when they moved the first application, written statement, and thereafter they have taken the plea, your lordship, a violation of section 8.1. Only they have taken a plea in the written statement, lordship, as regards the arbitration agreement. But no prayer as such is there, madam.
But What does the learned trial court look into?
Lordship, may kindly have a look page 199 onwards. Page 199. Both the parties are represented. The date is fixed today for passing of the order of the petition filed by the petitioner under section 5 and 8 of the Arbitration and Conciliation Act 1996. Read it Order 7, Rule 11D of the CPC and section 151 of the CPC filed by the petitioner's defendants against the OP's plaintiff. Copy of the petition has already been furnished to the learned counsel for the OP's plaintiffs who have submitted written objection in this case. I have already heard the learned counsel for the petitioners, defendants on the merits of the case and plaintiff's OPs. The learned counsel for the petitioners has submitted that the instant suit filed by the OPs is not maintainable in view of the existence of arbitration clause in the lease agreement entered into between the parties. The learned counsel submitted that clause 19 of the agreement provides that any
Whether there is
dispute
any order subsequently passed in the suit? Any further order?
after this.
My lord, suit has been referred, suit dismissed and referred to. There was an
Interim
No,
order.
where is the main, is there any consequential order passed after this case?
No. Lordship, may relevant portion page 2204. Last portion, this court cannot therefore continue with the trial of the suit in view of the existence of the arbitration clause, which mandates referring any disputes that may arise between the parties to arbitration. This court therefore deems it fit to allow the petition filed by petitioner and refer both the parties to arbitration. So and so is disposed of. Lordship,
Should notice
page
making
201 is
return
relevant
to
portion.
form. Making it returnable. 4th of June 2025. Okay. 4th of June 2025. Steps be taken upon the respondents by way of registered as well as usual. Within 2 days. In addition to that, the petitioner is also directed to take steps upon the respondents by way of the state, routed through the registry of this court and file an affidavit of service on or before the next stage. Next, the petitioner herein have assailed the order dated 29/4/2024, passed in Mizze case number 272/24, arising out of title suit number 27/2024, whereby the proceedings, whereby the dispute have been referred to arbitration in terms with section 8 of the Arbitration and Conciliation Act 1996. First, the learned senior counsel, Miss B. The learned senior counsel submitted that in the instant case, it would be seen that the written statement was filed on 30/4/2024 and the application taking reference under section 8 of the Arbitration and Conciliation was filed in the month of July 2024. Filed on 25th of July 2024, much after the filing of the written statement. The learned counsel further, drawing reference to the impugned order, submitted that a perusal of the impugned order is also would also show that the learned trial court, though agreed that the petition filed by the defendants was not maintainable, as the said application was filed beyond that was filed subsequent to submission of their first statement of defense. But then also, the learned trial court have allowed the said application. The learned senior counsel further submitted that a perusal of section 8 categorically mandates that this application has to be filed before submission of the first statement in the, before submitting the first statement in the dispute. Full stop. This court, upon hearing the learned counsel, senior counsel is of the opinion that the petitioner has been able to make out a prima facie case, has been able to make out a case for grant of a stay. Stay does not arise. Stay does not arise.
There was an order of injunction operating in our favor, my lord.
Can't help it. Stay does not arise. How can I stay?
Lordship, referring to arbitration that.
How can I stay? Suit is disposed. That is why I asked you.
Suit was
Suit has been
dismissed,
disposed of,
my lord.
so I can't stay that. You see, section 8 code does not although makes a reference
My lord.
that thereby asking both the parties, go and sort out your dispute.
Yes, then if
their
it doesn't
dispute
work out, then
before the
come back.
arbitrator. That
Yes.
is the power.
Yes, my lord.
But they don't appoint an arbitrator. They
Fair
don't
enough.
make it. It is for the court, the authorities then to take appropriate steps.
Yes, my
So
lord.
how do I stay this?
Lordship,
How do I stay it? If I stay it,
my lord,
a dead person, can I make it alive? So
it's true.
I have to only set aside this order.
Yes, yes, lordship,
Yes.
yes.
The learned counsel appearing senior counsel therefore submitted that the impugned order is required to be stayed pending disposal of the petition of the instant proceedings. This court is of the opinion that if a stay is being granted, it would amount to allowing the said application, the present application, even without hearing the other side. Taking into account the above, this court observes that without hearing the other side, no further orders no interim orders at this stage can be passed. The learned senior counsel, however, submitted there was an injunction order which was passed in favor of the petitioner.
Dated 29/1,
In
2020.
favor of the petitioners. However, on the basis, in view of the impugned order, the said injunction order has been vacated. Full stop.
One was the order, my lord, from 101 to 104.
Can't help it. Full stop. This court have duly taken note of the relief which have been sought for in the instant application. And there is no relief sought for pending disposal of the instant petition insofar as any injunction. Full stop.
Lordship, separate petition we have preferred. It's on record. It's on record. IA we have preferred.
Kindly see what is your relief, page 24 and 25. Liberty, however, is given to the petitioners to file appropriate application if so advised.
Lordship, we have
Oh, I
preferred
is there.
Lordship,
Oh, ikon nai. Ikon on I.
IA for injunction, my lord.
Oh, I is there. Ikonot eya kori dibo. Ikon, I had asked for stay of the order which order? This court is of the opinion that the question of stay of the impugned order does not arise, taking into account that if any stay is granted, it would amount to allowing the instant petition without hearing the other side. Full stop. The matter would be heard on the next date upon appearance of the parties as to what further orders can be passed in the instant proceedings. এখন main কোনো problem না, আর এখন this is an application filed, এখনো issue notice একে দিন। This is an application filed under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure for grant of temporary injunction from forcefully and illegally dispossessing the applicant from the Schedule 1 and Schedule 2 plots of land or any part thereof without following the due process. Full stop. Issue notice, making it returnable same date. Steps be taken upon the respondents by way of registered post as well as usual within 2 days. Full stop. In addition to that, the steps be taken by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. Full stop. The learned senior counsel appearing on behalf of the petitioner submits that on behalf of the applicant submitted that there was an injunction order passed by the learned trial court dated
29/1/2024.
29/1/2024, passed in Mirzia case number 35/2024, whereby the opposite parties herein were restrained from dispossessing the petitioner from the suit property till the next date. Full stop. Wait, was this extended?
It was extended, it was, there was another order was passed on 13/5/2024, my lord. For strict compliance of the order, my lord.
This is for another one, but where is the, any order is passed, but they, you say that there has been a violation for it.
Extended part it, my lord, as per instruction given by knowledge.
Huh?
It was extended. On
No, but there is a
instruction.
violation. Annexure 9, page 122.
They have violated your lordship, then again we have preferred, my lord.
Violation.
Yes, sir. It was operating. It was extended, my lord.
And where is the extension? There was an extension.
There is, your lordship. Part it was extended as per my senior, junior friend. my lord.
The learned counsel further submits that the said interim order, injunction order was extended from time to time. The learned counsel, however, submitted in view of the impugned order assailed in the accompanying revision petition. The said injunction order is automatically vacated. And if there is no injunction order passed by this court pending disposal of the accompanying petition, the petitioner would be ousted from the scheduled premises as described in the plaint of title suit number 27/2024. This court, taking into account the said submissions, is of the opinion that till the next date, the petitioner is should be protected provided the petitioner is in possession, no, it should be protected. First, accordingly, this court will be protected. First, this court further have duly taken note of the three conditions for grant of an injunction. And the manner in which the learned trial court have passed the impugned order challenged in the accompanying petition. Considering the above, this court therefore directs both the parties to maintain status quo as regards possession over the properties described in the schedules to the plaint of title suit number 27/2024 till the next.
Lordship, may it be mentioned Schedule 1 and Schedule 2 plot of land.
Properties mentioned in the schedule to the plaint of title
There
suit
is a
number.
certain dispute. They have shown one property, given possession to another property, part of government land, my lord. We have taken all the place in our petition, my lord. So there are two schedules, Schedule 1 and Schedule 2, my lord. Can it be mentioned in the order?
Now, in the plaint, I have given the both the schedules. What else do you require? I'm giving you
There are
more.
certain
you don't
developments
want.
while the lordship entering into a lease agreement, they have given KP Patta, but while giving possession without our knowledge, Annual Patta's land have been granted to us, your lordship, given possession.
You
That
want
is
for schedule A and B.
One and
That's the
one and-
schedules.
1 and 2, my lord, as per.
There's no schedule 1 and 2, page 14, page 47 of your IA.
Lordship, in our injunction petition para,
Isn't this the plaint? Page 47, isn't it the plaint? Then both the schedules.
there are changing situations, so we have filed certain FIRs also, my lord. They have forcefully tried to dispossess us. Lordship, in
So
spite
what
of their.
order do you want? Not to
Lord-
dispossess you?
No.
I don't know whether you have been possessed or dispossessed.
Status quo as regards Schedule 1 and 2 land, that may
It's
be.
not schedule 1 and in the plaint.
Yes, let him be.
My lord, what has happened, my lord? We were placed in schedule A plot of land of the plaint, my lord. That was the schedule given in the lease agreement, my lord. Then, my lord, we were placed in possession in schedule B land. There's a report of the circle officer also. On the basis of the report of the circle officer, we had filed the plaint, my lord. We had approached the civil court. Now, my lord, after all these developments, my lord, now when all those disturbances were going on, we filed numerous FIRs on record, my lord. Now, after we filed the FIRs, the police sought a report from the circle officer. Now, the circle officer backtracked upon the that other report he had given, and now he is telling we are now in possession in schedule 1 land. The injunction application.
Mr. Counsel,
Yes, madam.
kindly come to page 47 of your IA.
Yeah. My lord,
Where is schedule 1 and 2?
no,
Where?
no, schedule, I have placed schedule.
In
2.
the plaint, Mr. Bolwa, there are only two schedules,
Yes, madam.
schedule A and schedule B.
Yes, madam.
Now, are you saying that there is some other schedule then,
Yes, my lord.
and that is not a part of the plaint?
That is not part of the plan because we were not made known, my lord, because on the basis of the circle of schedule A is the, my lord, land given in the lease deed, my lord. And schedule B is the land which we had been fraudulently put into possession. We had been shown another land and we had been.
You are in possession of which land?
My lord, according to the circle officer Den, my lord, report, he told we were put in possession of Annual Patta land, my lord. The circle officer report is there. Now, subsequently, my lord, disturbances are going on. We had filed a lot of FIRs, my lord. The police, in order to see which we are possessing, called the circle officer for spot verification. Now, the circle officer is now telling we are in possession of schedule 1 land, but not in schedule B land. So, in the injunction application, my lord, I have in para this thing I have mentioned, my lord, para 13, my lord.
Mr. Counsel, your injunction which was granted by the learned trial court was only in respect to schedule B.
B land, Annual Patta land.
That was only extended.
That was extended.
Not any other thing was extended.
Yes, ma'am.
Where is
But-
the extension order for others, schedule 1, 2?
No, my lord.
Then-
Schedule one has come now, my lord.
Understood, so there has to be an amendment to the plaint.
Yes, we were not, because section eight petition was pending, everything was kept in abeyance. We could not amend it until and unless the section eight petition is,
File an application, because without that, how do I bring in schedule 1?
because
That is not a part of the suit. We are only concerned because the injunction which you have got means there is no injunction. Are you saying that?
my lord, we were told we were put in schedule B plot of land, my lord. So we sought an injunction on schedule B. Now the circle officer is backtracking on his report and telling us that no, you are in schedule one, my lord. If your, my lord sees
You were in possession under, on what basis?
on the basis of a lease deed executed,
Show me the lease deed.
lease deed is my lord, page 27. The schedule is at page 33, my lord. That is the schedule A land which I placed in the plane, my lord.
So you were given this.
In agreement, this was shown, but we were put in possession in schedule B, allegedly, my lord, on the basis of the circle officer report.
Then how can you be entitled to possession of this if you are claiming a basis on this agreement, which is the patta land? Because annual patta will be a government land or annual patta will be somebody's annual patta land. Not a government land. It's a somebody's.
Now they have file certain documents that the annual patta is their land only.
No, obviously. Therefore, it is a patta.
Yes, my lord.
Then
But actually, we have been put into possession in the annual patta land also and a schedule one land, my lord, not
Wait.
the schedule A.
then I can't help you.
My lord, this
Your
is,
entire basis is on this agreement.
no, but we have been, that is
No
my case, my
agreement.
lord. Fortunately,
will-
they have been put into possession. My lord.
Oh, there seems to be no injunction.
My lord,
Status quo as on today be maintained.
Huh?
Status quo as on
Status
today be
quo.
maintained.
Where? Where?
Lordship,
Tell me where?
as my learned friend is on instruction is submitting before his honorable court, we are on schedule one land,
one and.
One is not there
One
in
is
the
not-
suit.
but it's not.
There
part of
is
the
no, madam, there was no injunction granted by the learned trial court in respect to schedule 1. They have granted injunction only in schedule B. I can only continue schedule B. That's all. Schedule B
Lordship, may kindly have a look at para 13,
of
I. Para 13, page 19, that owing to such a referral being made to arbitration, the applicant herein has been rendered perfection, less as the restraining order of ad interim temporary injunction has been vacated, or the applicant stated as can be gathered from the numerous police complaints filed, the respondents are vehemently trying to dispossess the applicant from the Schedule 1 property and Schedule B land of the plain. That is a plot of land covered with dark number 42 of annual patta number 15 of village 1 number Bala Siddhi under Moja Choigao Pantan under Choigao Revenue Circle, in the district Kamrup Assam, which is more fully described in Schedule 2, appended hereto, and is herein after referred to as Schedule 2 property. The respondents, by employing certain other mannerisms, have been constantly threatening the applicant herein that they should dispossess the applicant now that there is no restraining order of injunction in force.
Madam, tell me, come to page 23 and come to page 47. What is the difference between schedule 1 and schedule A?
Name of the village, my lord,
Huh?
Bala Siddhi. Here, Bala Siddhi, I know. Moja Choigao Pantan.
So the difference is the village.
Yes, my lord.
Soigao, Putunda, Soigao Revenue Circle.
My lord.
And the second one? Village. But here
Lordship,
if you are claiming your right, it's only on the village, but all the other dark numbers same, everything.
lord.
North, south, east, west is everything is same. Then now your agreement is on the basis of no para.
No,
Revenue village, no para.
my lord.
So that is the plaintiff. This line. And schedule B. Schedule B. Schedule B.
AP number.
No, schedule B,
Patta.
no, schedule B is same village.
Bala Siddhi, my lord.
Both are same. Schedule 2 and schedule B.
Those are same, my lord.
Then what is the difference?
But in our, this one, no? Schedule one, where is the detail? It is the same, no? Hmm.
But how do you get any right over no para? If you are on the basis of a lease agreement, tell me. The lease agreement says about on a particular plot of land. Your basis is on the lease agreement that you should not be evicted without due process. Okay. Schedules to the schedule A and B to the plaintiff. Status quo as regards possession. Get your service done properly. We'll finish it off next day. Given a date. Fourth, na?
Fourth of June.
Production list, item 1 for motion.
Yes, what is it challenging? Huh? Who is there? Okay. Call as the last item of the day at 4:45, 4:30. I got no problem.
For admission, item 14.
Yes, what are you challenging? Who is appearing?
Actually, I am for the respondent.
You come this way. Man appears on behalf of the petitioner on call. Gusto. Mr. So-and-so appears on behalf of the, Mr. M. Talukdar appears on behalf of the respondent. It is also seen the records of the title suit number 77/2012 have not been received. The registry shall list the matter only upon receipt for the LCR, receipt of the LCR. Pusto. Take it, further to that, as the, have not been received. Pusto. The registry shall take appropriate steps for requisitioning of the LCR. Pusto. Taking into account that the LCR has been called for in the instant proceedings. The instant proceedings is admitted. Pusto. List the matter for hearing in the usual course. Liberty given to both parties to file application for.
15 and 16.
Keep of records, huh?
Please, Lordship, the 15, my lord, the only notice has already been if your execution has already been admitted, my lord.
Which one?
These are item number 15, my lord,
15 admitted?
admitted. Okay, one more question, this alternative division petition was filed, my lord, and that has already been defeated by this honorable court, my lord.
Where is the order in RSA?
Well,
It has been admitted by formulating a substantial question of law.
That, but the CRP number, my lord, CRP number 181, my lord.
Page? So RSA has not been
No,
admitted.
no, my lord.
Okay. Now what do you want here? What is this matter about?
My lord, basically, my lord, I take a little time, my lord. Actually, the judgment order, judgment decree passed by the London Appellate Court, my lord, is not in conformity with the provision, stated mandatory provisions of law as laid down under order 41, rule 30 and 1331, my lord.
Hmm.
There's a decision of this Supreme Court, my lord, in that case, my lord, the matter shall have to be remanded back to the first appellate court, my lord.
What is wrong with that order?
These are paid, the appellate judgment is at page 94, my lord.
What is wrong? It seems to be okay.
No, but that, this is not in.
You are referring to the judgment and order dated
Well,
31/10/2019.
Well.
What is wrong? It does decide by framing all the, by deciding the suit issue wise.
Well.
Then what is wrong? Have looked into all the evidence.
Well,
What is
No,
wrong?
no matter, that the judgment is completely, actually, they have not, any discussion with regard to the evidence on record, both oral and documentary, my lord. Simply by perfectly manner, the judgment has been passed by the first appellate court, my lord, without considering the evidence on record. And the judgment being not in conformity with the mandatory provisions
No,
of
no,
law. my
no.
lord.
Mr. Das,
Well.
merely saying that it is not in conformity would not make it not in conformity.
Well.
Now tell me, why is it not in conformity? Why I think two proceedings are filed. Why?
Well,
One is under RSA and the other is under 115.
50, my lord.
One will lie, both can't lie, or is it something different?
Well, what happened, the suit was filed for a specific performance of the contract. Then, my lord, there is counterclaim with regard to that, saying that he is the tenant and therefore recovery of the possession. my lord. So there-
And
recovery of
so the suit was dismissed. That is why the RSA is there.
Right.
So there, no, sir, it has not yet been admitted. As regards the defendant, your right to, you had filed the counterclaim. So your counterclaim was allowed for giving a decree for the year. So that was allowed.
Ejectment, my lord.
Ejectment was allowed,
Right.
holding him to be the tenant.
My lord.
So when that was allowed, so therefore 115. So we are only on the counts, the learned trial, both the courts came to a finding that he is a tenant. Tenant of the land or the house.
House, my lord.
Tenant of the,
house and land both are there.
you gave the house and land or what?
The house is there.
You are the tenant of what?
My lord, top
There is
premise-
of this, my lord,
top
the
premises is
house, my
there,
lord.
top premises is there.
Something like
Page
that.
40, my lord.
Shop premises.
My lord.
So you are the tenant of the shop.
I'm the landlord.
You are the landlord. So the question out here is, Mel2, bona fide and
Defaulter.
Defaulter.
Defaulter. Main issue is with regard to defaulter.
default. So the learned trial court has issue number.
Issue number 6, my lord.
6, my lord.
6. Whether the area is a trespasser, defaulter, undesirable tenant over the suit land in the area. Number 6. Let us see how the court has done.
Page 69. Page 69, paragraph.
The plaintiff did not file any written statement against the counterclaim.
Only that, on that ground alone, my lord, that the counterclaim has been
Finish.
allowed, my lord.
So no pleadings, no proof.
Hello.
Matter over. So finish. You see, the burden is on him. The moment he is the defaulter, it is he can't lead evidence on this.
Khalid, my lord, that actually, my lord, just, lost attention.
Matter over.
Well.
Sir, dismiss this one. And the other one? Why have you filed the second appeal? What is wrong with the second?
Not that second will be that, my lord, on the ground, my lord, actually, they know, as well, but the trial court as well as the past appellate court has not discussed the evidence on record, my lord, both are oral and documentary. In a most of perfunctory manner, my lord,
Huh?
the court has passed the judgment, my lord. There has been any discussion of the evidence, my lord.
Evidence.
No, my lord.
Let us see issue number
3 and 4, my lord.
3 and 4.
Page 66, paragraph number, and page 109, appellate court.
Oral agreement.
Oral agreement, my lord.
What is the perversity? Both courts
About
hold
it,
the same.
only they have admitted, they about the receipt of the advance money, my lord. That was exhibited, the receipt was exhibited, exhibit number 16 to 19, my lord.
Regarding?
Regarding the payment of the receiving of the advance money, my lord. On four occasions, about the altogether 54,000 was paid to the landlord, my lord, to the defendant, my lord,
But who has proved exhibit 16 to 19?
my lord.
Who has proved it?
The plaintiff, my lord,
How? No, plaintiff, no. Exhibit 16 to 19 is whose document?
our document, my lord.
Who has to prove it?
He has, the defendant has acknowledged receipt of the amount, my lord.
Understood. Who has to prove that? You?
Right.
Then
There actually, the court has held it, actually, this to be an agreement, this cannot be the agreement, this is only money receipt, my lord. Money receipt, we are acknowledging the receipt, but the advance money, my lord, by the defendant. But there is any specific, deep, my
Record
lord,
the
issue, my lord.
record.
Record not called for, my lord.
What is exhibit 16 to 19?
So 16 to 19 are, my lord, vouchers, my lord. It says,
Money.
it says, my lord, some amount, there are 4 vouchers, my lord, some amount is some 9,400, 10,000 is received for selling the suit land to the plaintiff, my lord. And
Who
my
has
lord,
signed it?
my lord, the signature, a short sign is there, but not, short signature is there, my lord. As per the plaintiff, it is signed by the defendant number one, but we have denied. And my lord, that was not proved, my lord, who have signed, and my lord, except that, my lord, only this statement that is in advance or in, for the selling of that land, nothing was there, only the number and button number is there. 4 line or 5 line, all these documents are there. Lordship want to see the.
Money receipts.
Money receipt. In it,
And what was the date of the money receipts?
it's 3 days, my lord, on the 3 occasions, my lord, this amount was paid, my lord.
Dates of the
Date
money
is
receipts?
1/8/98, then 5/1/99, 9/2/99, and 15/4/99, my lord.
And you filed the suit in 2007.
Mhm.
So no care for specific performance also.
No, limit days about it, this contract limit, there should have been an. there should
Maybe
be
I saw
proper
a
issue, my lord.
judgment, Mr. Gupta, have you got that judgment that even a person who is a tenant is bound to pay his, whether he enters into an agreement or not? He will be defaulter there. He may get a suit for specific performance, that's a different thing. But he will be a defaulter, he has to follow. Not look into the judgment. Get hold of that. And there the other one, the court, both the courts hold it that exhibit 16 to 19 is not proved. What is the perversity? Perversity? No case.
No witness was examined, nothing.
Okay, when should we dismiss it? You get hold of the judgment. Ah, this is a judgment by, that happened 2 years back, the judgment. So, Mr. Das, when should we dismiss it?
My lord.
Give me a good date.
My lord. No, but yeah, so since the 98, 91, 98, my lord, is doing his business, my lord, in the.
When?
myself. My lord,
We dismiss it together
Well,
on one day.
since
Good.
1986, my lord. 10/8/1986, my lord. By agreement, memorandum of agreement, he is by possessing that suit house, my lord, suit premises. And be carrying on with business, my lord,
So,
till now.
does it make you the owner?
My lord, that, there was an agreement, my lord, oral agreement. my lord, that
Agreement
is-
for, to sell at what price?
That's one lakh, just a minute, my lord.
Is it mentioned?
Yes, my lord, we have
The-
said, my lord.
The exhibits, nothing
Yes,
is
sir.
there, my lord. And even the no person was examined to prove that exhibits not.
Nothing.
1,50,000, my lord.
Where do you get it?
There's, you know, the British, my lord, we have said, in our place. also.
Feelings won't help you. Feeling is not proof. So when do you want it? Dismissal. We can have it on. Okay. We finish it off on 3rd of June.
Right.
3rd of June, last date. Okay. List this matter. Put the matters on 3rd of June. In the meantime, we'll have it on 10th of June.
Right.
10th of June. In the meantime, the registry shall ensure that the records of title suit number 39/2007, isn't it,
Yes, sir. Correct, my lord.
is placed before the Scot on the next date. And list this matter on 3rd of June. List this matter on 3rd of June in the column of order 41 rule 11.
Now, original suit was, my lord, 9 of the 2006, my lord, it was renumbered as title suit number 39 of 2007, my lord.
We'll go as per 39.
public told.
From the court of the civil judge,
Not just.
senior division.
Senior
Senior division, because the, I think the district judge passed this judgment, no?
Actually, that means district judge by district.
So we need to finish it. What are you challenging?
My lord, this is a case where the petitioner has plaintiff sought some execution of the decree in a land which is my land. Actually, this Khajurali, the respondent filed a title suit. That lordship may kindly see page 14. Page 14. So, page 14, kindly see first. And the schedule of the land, page 17. District Gwalpara, Circle Lakhipur, Village Rakhal Killa, Dag number 254255, Patta number 94, land measuring 1 acre, which is bounded as follows. North Saburuddin Sheikh, South Solimuddin, East PWD Road, West Solimuddin Sheikh. So the present petitioner did not appear in the court because he thought that this is not within my land.
Where's your written statement?
No, she did not appear. Ex parte decree was passed.
Then,
And then, my lord, they filed a petition for execution of the decree. And when the execution of decree petition was filed, and they went to the land, this court master and others went to the land, it was found that the land is totally a different land. Kindly see now page 27. This is the decree, schedule 28. The same thing which is discussed in schedule of the suit land. So after that decree, my lord, they filed a execution proceeding, and we filed a petition under section 47. When they went to my land, we filed a petition before the learned Munsif that the land which he wants to occupy through the court's verdict is not the land for which he has filed the suit. Then that was considering that statement, the court passed an order that lordship may kindly see page 38. And on our objection, my lord, the learned court issued a notice, that is page 40, issued a notice to the assistant settlement officer, Lakhipur Revenue Circle. Most important thing is this, page 40, where the judgment debtor filed a petition before this court stating that the decretal land does not tally the scheduled land. Therefore, it is hereby asked you to make an inquiry regarding the existence of the below mentioned land and to submit the report before this court on or before soon. A plot of land measuring 1 biga, so that is there. So now see the boundary, North Saburuddin Sheikh, South Solimuddin, East PWD Road, West Solimuddin Sheikh. So court issued this notice to the settlement officer that you inquire the matter, what is the
status of the land, what is the location of the land. Thereafter, my lord, the officer sent the Latmondal to the field and he filed a petition.
Did you appear in the court or not?
Later on, I have
In,
appeared.
in the trial court?
Trial court, I did not appear.
Did you file an application on the order 9 rule 13 or not?
That was not done because that was not done. No, actually, my lord, regarding decree, we have no any objection. What decree they have got, if they get that land, we have no objection. But in the name of that decree, they want to take our land. Now kindly see that everything would be clear. Just 47 now kindly see. This is the report of the Mondal submitted to the Assistant Settlement Officer. Report regarding page 47, Annexure 10. Report regarding the order of the Honorable Munship number 1, dated so and so. With due respect and in the context of the aforesaid order, after inquiry, it is seen that in the village Rakhali Killa, under Lakshmipur Revenue Circle, all patta number 94, new so and so, all dag number so and so, new dag number so and so, total 1 biga 17 lesser land, states in the names of Jolibur Rahman, son of Jabbar Ali, Joveda Khatun Bibi, wife of Solimuddin, Johurul Haq, I am the petitioner, son of Solimuddin, Hajor Ali, the respondent. So, the boundary of this land as appears at present, there is no similarity is seen. After local investigation, it is found that the boundary of the said land at present as follows. Can listen now. Here boundary is in north Umed Ali and Hakim Ali. And in their suit, they wrote North Sobruddin Sheikh.
What is the boundary in your sale deed?
Boundary according to the sale deed, lordship.
Boundary?
According to the sale deed.
You purchase what? What did you purchase by that sale deed?
1 biga of land, lordship.
Understood. From what is the dag number and patta number?
Dag number, lordship. Dag number 254 of it, 255 old, lordship. Patta number
Of patta
94,
number 94.
lordship.
You purchased
Yes, lordship.
in the sale deed.
Yes, lordship.
Where is the sale deed?
Lordship, sale deed I have not annexed here.
You have the sale deed with you?
At present, I don't have, lordship.
How are you saying that yes, you have purchased it?
I have submitted the trial court, lordship. I have submitted.
Because here, what is the report is being given? It is seen that in Rakhawala under Lakshmipur, old patta number 94, new patta number 136 of dag number 2 year, new dag number so and so. Total 1 biga 17 is in the name of Jolilur Rahman. Who is he? Son of
Jolilur Rahman?
Zubair Ali. Zabida Khatun Bibi, wife of so and so. And here, who are you? What is your
I am
name?
Johurul Haq.
Joriul Islam.
Johurul Haq.
Your Joriul Haq. Now, suit is filed against Joriul Islam.
Johurul Haq.
Huh?
Johurul Haq.
Solimuddin.
Plain.
Okay, so they have filed it against the wrong name also.
And the totally different land, madam. Their land is, I think, I have mentioned in my petition, that is, my lord, nearly 1 kilometer perhaps away from that land. Now they want to occupy my land in the name of decree. 1 kilometer away, kindly see para 3 of my petition, that 1 kilometer away, they want to take that land.
Where is the decree? Judgment and decree?
Yes, decree.
Page?
Page
One
19.
nine.
19,
19.
Lordship.
No, show me, brown, produce the, yeah, sale deed. Because the decree is passed on the basis of the sale deed.
Lordship.
And sale deed, what is the boundary? Because here, the report which is giving at page 47
Lordship.
is that old patta number 94, new patta number 136.
Lordship.
New patta, when did it happen? And old patta number, dag number 255, new dag number total 1 bigger area stands in the name of Zoliur Rahman, Zabeda Khatun, and Zahrul Haq. Zahrul Haq is who?
Jailok is the present petitioner, Lordship, dependent in the.
Is the defendant in the suit.
Lordship.
So it has gone ex parte.
Lordship, it has gone expertly, but before that, Lordship, they received the notice, appeared before the trial court, took time for filing the WS, thereafter they remain absent. So it has gone expertly. And in the execution case also, they got notice, appeared before the executing court, took time for filing written objection, then they remain absent.
This petition is being filed by them.
Yes, Lordship.
Then they appear before the executing court.
Yes.
No, Lordship, not before the execution. They filed the petition under section 47 only after the writ of possession was there.
Understood. They filed a 47 petition.
But in the execution petition, they did not file any objection.
That is not necessary, but they filed a 47.
Lordship.
47, the court had decided it
Yes, Lordship.
on the basis of it. Now the courts holds it. The
That
court,
order, that order I have annexed in my
where is your application for changing the name?
affidavit in opposition. At page 9, Lord. In my affidavit in opposition. Why they have filed a petition on the 47 contending that the suit under the plaintiff is vague and ambiguous. That was dismissed by the executing court. Thereafter, they filed again a petition seeking setting up of a commission to identify the land.
My lord, kindly see the court's order, page 38.
No, Mr. Main problem is this. The court under 47 has the power to correct it.
Yes.
Because in view of that Pratibha Singh's judgment, the court has the power
Decree
to
may be
correct.
corrected.
This
But
schedule
here,
can be also corrected.
schedule can be also corrected, but that is not their case. That after purchasing this plot of land, their boundary has been changed. That is not their case. So there must be something on record that the earlier totally different and 1 kilometer away, that land.
Now, where is their application for change?
And court has issued a commission on for that purpose, that to ascertain the land. Can you see page 39 bottom? when the court has taken a view that there is a dispute regarding the actual position of the land, kindly see page 39, bottom, on consideration of the report submitted, I deem it fit to call for a report from the learned SP concerned as to the amongst the costs required. That is, he has
Now, this is for police help.
police help that. Thereafter, my lord, thereafter also, he has passed order to the, that is page 40.
Page 40 is prior to that.
Now, Lordship, kindly see, page 37 bottom. This is a court's order. Considering all, I find that bottom, page 37 bottom, I find that as the boundary of the digital land is in dispute, setting up of a commission will be of utmost essential for determining the matter in controversy by this court.
Now, understood, where his petition that the boundary is bad, where is it?
I have not annexed that. I have not annexed that, but
Did you file a petition
a
for
petition was,
correcting the boundary?
a petition was filed for amendment of the boundary laws.
Where?
At present, I have not annexed the with this lordship.
You have a copy of it?
I will file lordship by filing it. Because of lordship kindly
No,
paragraph
nothing,
Four of
no
them
pair of
digital
business out there. First of all, your petition is not known what it is. You seem to be not interested.
no lordship kindly.
Well, Mr. Mahmood, one thing let me tell you. Why are you not filing an application for setting aside the judgment and decree now? Under order 9 rule 13,
May be done, but it's a long time, it's a long
not
time.
necessary because in view of the amendment, now you become interested.
Yes.
Earlier, you may not have been interested.
Because the boundaries are totally separate.
So why you are not filing it now? Because anyways, there are many judgments of the Supreme Court, every stage in ex parte proceedings. You may have appeared at the time of filing of the written statement and you did not file. Thereupon the suit has proceeded
Yes.
and a decree has been pronounced. And therefore, then you may not have been necessary because the boundary is wrong.
No,
Now with this, the boundary is yours, so why are you not going there? Because without that, the problem is that the executive court has the power under 47.
petition was filed under 47.
Mr.
That was
Counsel,
under 9 rule 13.
47, with that 47, the court can correct it.
But
See
did
the
not correct-
judgment of Pratibha Singh in 2000
Yes, sir, that is
2003.
there, well,
If you look into it, the court can do so. So therefore, you will be in problem. Why you are not filing an order 9 rule 13 and give that explanation to the effect that now it has become necessary and ask for stay? There's already a stay proceedings to the execution proceedings.
Yes.
Let me have it. Go and file that.
lordship is on that some time may be allowed till we file the order petition under order 9 rule 13.
I'm adjourning this for another 4 months. Get the thing done.
But simultaneously two proceedings, it may be that without observation of the High Court, how can, because here is a proceeding for the same
Don't
subject.
require, you don't require an observation from this court. There is no bar. Can there be any bar for filing an appeal? I'm only taking up a 227 proceedings. That is against an execution proceedings. Now, how do you stall the execution proceedings? You are such a seasoned lawyer, you know
We
how to
do
do.
not want to stay the execution proceeding, but execution should be on the digital land.
Understood. Now, therefore, you go up before the court and file an application under order 9 rule
That
13.
some
That now
observation,
it has become like this.
some observation, otherwise then we travel. The court may say, already matter is pending in High Court, they may say. So that is, we are afraid of that. Lordship, kindly consider the practical aspect of the case. When there is the High Court, lower courts, every time they refuse to entertain. So if there is a little observation, that they may
Lordship,
find,
the question is now only the identifiability
yes,
of the land, truth land lordship. That can be identified by Dag number and pattern number also. And Dag number and pattern number is the same, only boundary men are different. He is not,
I
he is not
understand.
disputing the draft number and patta number, Lordship.
Understand, but it is in the name of somebody else. There the problem arises. Have you seen the report of the extent that circle officer?
You have got ample chance, but they did not put in any document to substantiate that this is their land.
Therefore, heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so appearing on behalf of the respondent. The present application has been filed by invoking that the supervisory jurisdiction of this court this court. The Article 227 of the Constitution, challenging the order dated 29/9/2022, passed in title execution case number 3/2015. Whereupon the learned executing court, that is the court of the learned Munsif, number 1 Gwalpara, had in exercise of the powers under section 47, corrected the schedule of the land and directed for proceeding with the execution of the decree. Pusto. The learned counsel appearing on behalf of the petitioner submits that though the petitioner was a defendant in the suit, but the petitioner did not appear in the suit pursuant to taking into account that the land in question was not the land wherein the petitioner was actually in possession. And as such, it was not necessary. He further submitted that subsequent to the decree being passed in a completely different land, which can also be seen from the order dated 24/9/2019, as well as 29/9. The decree holders have now proceeded to execute the decree in respect to a land which belongs to the petitioner. Full stop. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner has filed any application for setting aside the ex parte decree and order, decree and judgment and decree, taking into account that the judgment and decree was passed ex parte against the petitioner. Full stop. The learned counsel submits that there was no necessity for filing an application for setting aside the judgment and decree, taking into account that the land which was decreed was not the land where the petitioners are in occupation thereof. He, however, submits that at present, the petitioner would be well advised to file such applications seeking setting aside the said ex parte judgment and decree. However, he submits that taking into account the present proceedings, the court may not permit such application. Full stop. This court is of the opinion that the present proceeding arises out of an execution proceedings which have no relation with an application being filed under Order 9, Rule 13, or even an appeal filed under Section 96 against the judgment and decree passed by the learned trial court. However, subject to being permissible as per law. Full stop. Taking into account, full stop. This court further inquired with the learned counsel appearing on behalf of the respondent herein as regards the application filed by the petitioner, by the decree holder seeking amendment of the decree, as well as also the sale deed on the basis of which the plaintiffs, the decree holders have got the decree. Full stop. the learned counsel submits that he would file an additional affidavit bringing on record the said, full stop. Taking into account the above, list this matter again on 16th of July 2025. Interim order passed away shall continue till then. Given you 2 months, do something.
Admission item 17.
I have also formulated what you need to say in that application also.
Alright.
Yes, transfer, who wants to go where? Yes, you want to go to where?
I want to go to Tezpur, Lordship, Tezpur.
You want to go to Tezpur
Yes, Lordship.
from
From Barbeta.
Borpeta? You want to go to Tezpur?
Yes, Lordship.
Where was
District
the
Judge
marriage
Panel for
solemnized?
Tezpur. Yes, Lordship.
Marriage was solemnized where?
On 19/11/2017, Lordship. As per Hindu rites and rituals, as well as special marriage act, Lordship.
Hmm.
I've already annexed. Kindly see page number 16. Marriage certificate, Lordship. Page 16.
Why do you want the transfer?
Actually, Lordship, petitioner has a minor daughter and she's residing with her parents. And there is no one to accompany her to Barbeta.
What
to
do you
progress
do?
the case.
What do you do?
I am unemployed, Lordship.
Where's your statement?
I have not stated that, but Lordship, kindly see paragraph 5, page number 4.
Now your child is big, 5 years
You're
old.
6 years old, Lordship. Only 6 years old, Lordship.
Then now you can go.
No, Lordship.
Okay. Allow go. Allow. You go and appear in Tezpur on 20 June. Appear before in Tezpur and file your written statement. Allowed.
18.
Transfer petition, madam. Transfer of a suit for divorce, madam, from Soraigil to Nagaon. Madam, there is an order in the Law Zimba court, madam. The notice was deemed to have been served upon the sole respondent.
Why?
Madam, basically, madam, in the year 2020, after she left, the petitioner left, she filed a TV case in
Huh?
Nagaon.
What suit has been filed?
Divorce, madam.
Huh?
Divorce. This is at
You stay in Nagaon?
Nagaon, madam. And the suit was filed in.
How many
Soraigil,
cases you have filed?
madam. A domestic violence case which is pending in Nagaon, where this person is contesting.
How many cases you have filed?
One. One.
Only one.
Yes, in Nagaon, he is contesting, madam, regularly. And this matter is fixed for defense evidence. But he, my lord, in 2023, filed this divorce suit, my lord. It is on page number 42.
Allowed. 20. File your written statement at, where do you want? Nagaon.
Nagaon. High level.
19.
Hmm. What are you challenging?
Challenging the order date, my lord, annexation 9A and 9B, my lord.
9B also. How
Yes.
many orders you are challenging?
This
We
is a
have only
continu-
9A.
This B is a
59.
continuation of the
It's
nine.
59,
Page?
59,
Okay, what is this?
9A.
And I am going to submit the report of the following the consultation we are likely to- So, what is wrong?
My lord, our objection is page 55, my lord.
No, what is wrong with that order?
Because in the plain, they did not bring these materials, my lord. That is another document is there, this thing. And we had not the scope of this. Suit was agreed. Then we sought for additional evidence. It was allowed by the court below. They objected it and came to High Court with revision. That revision was dismissed and matter remanded. Then at this stage, they have bring this allegation that contains a new story. That another document has to be verified, examined. These things, they did not at all speak in their plain, my lord. This is
Which one? Which application is theirs?
their application, my lord,
At page
at
47.
Annexure 7, page 52.
You are the appellant?
You are the
I
respondent.
am applicant.
He's the appellant, I'm the respondent.
What do you want? You file an order 21 for 41 rule 27?
So they had filed.
Then who are you asking, what is this application?
This application we had filed because already there is an order that the thumb impression of the defendant number one, that is appellant number one, would be sent to the handwriting expert. In the meantime, the appellant number one, he has expired. So there was a sale deed of the year 1977, which was transferred by the appellant number one in favor of his wife. There also his thumb impression is expression is there, madam. So we wanted that document to be sent along with the thumb impression of the sale deed that was executed in my favor. Because as he has already expired.
So you mean to say that the comparison has to be done along with another document? So not only with this document. That is what,
It was allowed.
so how is it wrong? I would have understood if he was asking for any other evidence. No. What he is asking, that the compare, you see section 45 and the court's exercising the power under 73. The court is saying that, look, they will be going for comparison of the signature. That is what he can do. The particular court, the forensic laboratory will make the comparison with something. So they say that along with that, kindly take the thumb impression of they compared this also document. So what is wrong? You can't interfere with 227 with this. Therefore, dismiss, withdraw, which one?
Better withdrawal, ma'am.
Mr. M.H. Rajbal Bhuiyan, the learned counsel appearing on behalf of the petitioner, and Mr. A. Iqbal, the learned counsel appearing on behalf of the respondent. Is an application file challenging an order dated 7/1/2023 passed in Mize case number 53/2022, whereby the learned trial court, learned first appellate court, along while permitting the examination, while permitting the application so filed by the petitioner under order 41 rule 27 for adducing additional evidence through handwriting expert, had also allowed that the thumb impression of the defendant number one be compared with a document which was placed by the respondent herein by way of a petition filed
At page 55.
petition filed by the appellant in title appeal number 07/2. Appellant is he
Is
who has filed this query. You filed this petition, page 52.
52 was filed by them, my lord. 55, 52 I filed, my lord.
Ah, you don't know your case. Filed by the respondent in title appeal number 07/2017. Mr. M.H. Rajbhuyal submits that he would not like to press the instant petition. Considering the above, the instant petition stands closed on withdrawal, full stop. The interim order dated 17/5/2023 passed in the instant proceedings stands vacated. And the parties herein who are duly represented are directed to appear in the First Appellate Court, the Learned Court of the Civil Judge Gwalpara, the First Appellate Court on 2nd of June 2025 for further proceedings of title appeal number so and so.
Of line.
Number?
7.
My goodness.
7 of 2020.
This don't seem to be much here. 7 of 2017.
Of line. Item 20.
What is this?
My lord, we have challenged the order dated 5.
My lord has heard sometime back this matter.
Compromise decree.
Power of
compromise.
attorney challenging the.
My lord, we have.
Oh, this is a 151 challenge
uh,
to a compromise decree.
Compromise decree for, we have filed petition under order 23-3 for recalling the order, compromise order.
How? It has to be filed under 151 only. There's no way out.
There is, as per provisions of proviso, my lord, the recalling petition can be filed under order 26, section 3.
That is there. Under the provision, the court passed the decree, you have to approve that court.
Recalling, we have
Under?
Under order
23.
23, decree provision.
Provide.
Who?
The court passed the compromise.
Recall.
To
It's a
recall.
call.
Huh? Is it?
If it is not.
When did it happen?
it?
No CPC can do.
The Supreme Court also says. so,
Say,
my lord.
Supreme Court never said it.
Yes, ma'am.
this says.
There is a judgment.
Yeah. 23. Rule 3. Provided that where it is alleged by one party and denied by the other party, an adjustment or satisfaction has been arrived at. The court shall decide the question, but no adjournment shall be granted for the purpose of deciding the unless the call is raised. Where is it? The only power, as I know, as per the various judgments, starting from 1991, there is one judgment, and recently Justice Dhulia has also
Yes,
passed
yes.
the judgment,
Good.
where the power is only under 151 for recalling.
Para 15 and 16.
23(3) proviso does not say so. Where?
No, this is not.
How is this judgment?
No,
relevant?
this is not right.
Huh?
I'm sorry. This is. Okay, no.
There is another,
It will be there.
let us sought, my God, order by the Supreme Court in the nutshell, relying upon the Banwari law. It is said, my lord, one paragraph.
Banwari Lal is the 2019, 91, 94, 95,
93.
93.
93.
Ah. There is one paragraph where it says in Banwari Lal, one can file under 151.
Order of, this is that the appellant had thus the right to avail either the remedy of appeal in terms of the order 43-1 CPC or by way of an application before the court granting decree. Therefore, the application filed by the appellant before the court which granted the decree cannot be set aside as said to be without jurisdiction. So, my lord, to relief RDR, provision of relief, my lord, RDR, one is appeal under 42-1A, new section, my lord, and another.
Only the power is there is for recall.
Yes.
And the power of recall is under 151. Anyway,
No,
why,
no,
why
no.
is it necessary? We will convert into 151 and
My lord,
consider it as 151. Now tell me, what is wrong?
my lord, wrong is this, my lord, as per 23, my lord.
Ah. What is the opinion of the court? It is done.
My lord,
From the above, this opinion has failed to prove the allegation of fraud against the OP with respect to the compromise entered into between Liman, and as such it is decided that the attorney holder is competent to enter into a compromise as it has been decided that it is not a void or violation. Okay, now let's see your application under 151. You filed the application.
yes, my lord. Before that, they have filed a compromise petition, my lord, on that.
It's okay. Where is the allegation of fraud?
My
The
lord,
fraud has
before
not
that-
been pleaded, my lord.
Before that,
Their application does not say about the fraud. They have alleged against their own attorney.
my lord,
And therefore, in the last occasion, Lordship has indicated that you have to file the FIR against your own attorney if he is misrepresenting.
Oh, attorney is here somewhere. Somebody is appearing for the
Yes,
attorney,
yes,
na?
yes.
Ah, remember?
Yes,
He-
that
he
case.
He
my
was
lord.
this side this
my
time.
lord,
Yeah,
in this case, my lord,
Isn't it? Ah.
that is the case. My
Then I
lord
asked
has
him, yes,
indicated
yes.
that you have to.
compromise petition was given by both the power of attorney. They also introduced power of attorney holder. We also introduced our party. also.
Understood, but your power of attorney holder against you have not done anything.
No, my lord, there is still time is there, my lord.
Why?
Because he has stated he also defrauded by the plaintiff, my lord.
How is the time there?
My lord,
Because the time was in 2023, you filed this
yes, my
application.
lord. Now he stated that they have not given money,
Compromise happened in 2022.
but my lord, here important point is there. my lord. In deciding for the petition of the compromise under 23,
Hmm.
the compromise petition or compromise deed must be produced before the court. There is no compromise deed. They have filed a joint compromise petition before the court, my lord.
So?
So, my lord, whether it is lawful, it is the duty of the court at the time of filing the compromise petition, that it is lawful. If the compromise itself is not available.
You are alleging fraud upon the court.
No, not court, my lord. They have not produced the document. The document, the deed of compromise, which is required after the amendment of 76, my lord. Earlier is the oral submission is accepted, my lord. But
Now what
after
they have
70
done?
76, my lord, there must be a written agreement, my lord.
Ah.
And that written agreement is not there. Only a petition before the court that we have agreed on the so terms, my lord. Terms are definitely terms are legal, my lord. But where is the term, my lord, in the compromise deed? That deed was not produced before trial court, nor actually there is no execution of any compromise deed. No compromise deed or agreement. In written compromise, which is requirement under order 23, my lord. The terms, my lord, terms that we have agreed, that some terms is reflected in the petition before the court.
It is there,
Yes, my lord.
312, all these things,
Yes, my lord.
31237.
This is the terms of the compromise. They have made a compromise. The compromise terms is there. Where is the compromise deed, my lord? There is no compromise deed. Oral compromise we will not do, my lord, because 76 amendment. After amendment, there cannot be.
Mr. Dekha, are you?
Yes, my
It
lord.
seems
Kindly
that
see.
what you are submitting, all this, it seems that I've forgotten the law.
No,
No,
no.
it doesn't seem
It
so.
is not possible for
You see, where it is proved to the satisfaction of the area that adjusted or in part by lawful agreement
Yes.
or compromise in writing and signed by the parties.
Yes, my lord. Lawful agreement, my lord. That law-
Where is the word lawful agreement or compromise in writing
Yes, in a
and signed by the parties?
compromise in.
So
writing,
are
yes.
you saying that where the parties have jointly filed an application before the trial court
Yes, my
stating that we have duly entered into this compromise, these are the terms of the compromise, the court cannot?
court cannot, my lord, because.
Show me that.
My lord.
No, show me that. I've never heard of this type of.
My lord, we have filed some. What is-
There has to be a separate agreement that is never heard of.
Because my lord, without agreement, whether it is lawful or not, court will to have to pay it, my lord.
You see, therefore they use the word or compromise.
Or compromise in writing, my lord.
That is writing. The
It is not
petition is in
compromise writing,
compromise.
it is, in the agreement, it is the petition, my lord.
Show me, where is that? Where the Supreme Court says so?
Me, come to decide. Yes. Even my lord, please, copy is there. Okay, madam, get it down.
Which one?
My lord, in 24.
Huh?
Here, Supreme Court, this is not given, my lord, no citation given.
Which one?
My lord, here.
Ah.
2024, my lord.
Ah.
5513, my lord.
55? AIR.
Yes, my lord.
Where is it?
5513. My lord, I am reading the para 9 of the, without,
No, give me the name of the party.
name, my lord.
Amro Devi.
No, my lord, Vikram Nath, sorry, Amro Devi, yes, Amro Devi.
Tell me.
But para 9. It is the trial court by order dated 19/12/92 dismissed the suit. There is other relevant facts. my lord. It held that the proceeding under Order 23, Sub-Rule 3 of Code of Civil Procedure 1908, the existence and production of written compromise between the parties duly signed by them is most important. It relied upon the ruling of the court in the Gurpreet Singh versus so-and-so, Gopal AR 1988 Supreme Court 400. Since the said compromise was not presented in written form duly signed by the parties, the mandate under Order 23 Rule 3 CP is not fulfilled, and thus it lacks legal force. The trial court also held that the statement before the district court cannot be treated as agreement or compromise. On the fact of possession, the trial court noted that the plaintiff could not prove that they were in possession, so and so. my lord. So this is the finding of the district court, and it is affirmed by the Supreme Court in the last parameter, last but one. 23 page. In the present case, neither the compromise has been reduced in writing, nor it is recorded by the court. Mere statement of the parties before the court about such said compromise cannot satisfy the requirement of Order 23 Rule 3 of CPC. Therefore, the compromise decree is not valid. So, my lord, that is affirmed by the district verdict is affirmed by the
Where does the Supreme Court say that?
last my lord, paragraph, my lord, 23. In the present case, neither the compromise deed has been reduced to writing, nor it is recorded by the court. Mere statement of the parties before the court about such said compromise cannot be satisfied the requirement under Order 23 Rule 3 of CPC. Therefore, compromise decree is not
So
valid.
what happened in this case?
In this case, in view of the above analysis, the present civil appeal is allowed. The order passed by the High Court and First Civil Court is set aside. The judgment and degree of the trial court, that is so and so, this meaning it should is confirmed.
The execution of the sale deed does not equal the completion of the Ah, see, I can't be wrong. Paragraph 13
13.
of that judgment, Amro Devi.
13 million.
Yes. What happened in that case? Before the first appellate court, the plaintiff respondent therein, Bihari Lal, gave a short statement to the effect that they have reached a settlement re- receive money, and that possession and ownership of the land could be with the appellants. Mansaram and so stated that they have reached a settlement with the appellants and they agreed to the statement of the appellant that the suit be dismissed. At the same time, appellant so and others stated that they have reached a settlement with the respondent that they have paid money to so and they all by year. Based on these statements, the decision by order accepted the appeal, set aside the judgment of the trial court and dismissed the suit. See? Without reading the facts, you can't.
Some other judgment also there, my lord.
Show me, show me. Let us be enlightened today.
Yes, my lord. It will be a leading case, my lord.
Eh?
It will be a leading case.
No, it won't be leading. First of all, Mr. Dekar, the direction which you are going, before this court is a direction which you should have come immediately after recording of this compromise and coming before this court under 227, not moving in the 151. You move the 151 on the basis of a fraud or whatever may be. You can't do that, but you have to come here under 227. Anyways, let us go further. Consent, judgment and decree, challenge, non-repealable order, remand, withdrawal of the suit, allegation of fraud, supervisory jurisdiction. No. There's nothing. Oh, this is a very interesting case. Navratran Lal Sharma. I remember this case. Now here is the case. This is very interesting. This case has no relevance.
It's a bit- it's well-
Navaratran Sharma,
Parat will be there.
Huh?
Parat will Miller,
para 12.
Parat will Miller, which is related to the government of Puspa Devi Miller.
So what do you say?
The law in this issue is summarized in Puspa Devi versus Man. In this case, the court also took note in section 96(3) of the CPC and the relation of order 43 rule 1M of the CPC by way of an amendment in 1976 as well as order 23 rule 3A.
No, you
The
see,
consequence-
Mr. Dekar, kindly see, this is in respect to explanation. You have to see the facts. There were certain checks which were required to be paid. These adjustments and all have not been done. The court can still entertain and order the explanation, the proviso to, the 23 rule 3.
Rule 3 provision.
That is permitted. But what the Supreme Court said out there, that a court which have the power to entertain the compromisee has the power also to look into as to whether it is lawful or not.
Yes, my lord. Yes.
So this is it. What is
Yes,
the,
yes,
what is the effect of
exactly,
it?
my lord.
So the
But-
power is there. There is no quarrel with
Power is
that.
there, my lord,
Yeah.
but he has
But
not
the
exercised
question
the
is
power.
fraud.
Power is in the exercise because at the relevant time,
Huh.
at the relevant time, before the court, only terms of the petition is, only terms in the petition is there, my lord. The agreement, compromise agreement whole is not there, so he cannot verify whether it is lawful or not, my lord.
Hmm.
Only on the basis of terms, my lord. Will file in petition, my lord. This is a petition before the court. So, my lord, when there is no compromise, deed separate this in
No, no,
writing, my
it
lord.
is not required.
My lord,
That is not required.
my lord, it is, I'll further satisfied, my lord, but it is required because
Okay,
Because-
learned counsel, senior counsel, Mr. P.S. Dekar submits that you. Yes, upon hearing the matter at length, the learned counsel, senior counsel for the petitioner submits that some more time may be granted so that the petitioner may, the council may
there are other point also there.
address this court and look into the, further, after looking into the case laws, list this matter when.
There.
8 or 9, my lord.
No, he is in
June.
or before or after, my lord.
8 is Sunday, you want to come, you can.
Oh,
9 is
9,
Monday.
9.
I'll outside, my lord.
Okay.
8th of
After-
June, Sunday, my lord, no, on Sunday. 10th, my lord.
We will keep your word.
Or 19 June, my lord. 18 or 19. Lordship is, the bench is,
9th of September?
no, Lordship,
Yes,
9th of
madam,
September?
madam may be part, my lord. Madam may be part.
No, I don't keep it part of it.
Lordship, 19th September, matter will be disposed of because for pendency of this, the decree also could not be executed.
We have not- we
That
have
is the
not
whole trouble. my
Paid
lord.
the money, my lord, 44, 6 lakhs.
That's another matter.
Agreed, my lord.
Might not may,
19th June.
might not.
Liberty given to both parties to mention the matter for upgrading.
Yes, ma'am.
Do you require, did you give evidence?
My lord,
Did you
No,
give
no,
evidence
no,
before
no,
the?
no, no.
no,
See?
no. Subsequent petition, I have not given any evidence, but
Yeah.
earlier order,
No. Did you give evidence in the 151?
no.
Then
whether without
Yeah,
evidence.
yeah,
you-
that,
your
lords-
submission,
lords-
you,
my lord has indicated, but they have not opted, so therefore there is no, there would be no.
Still,
how do you prove the fraud?
my lord,
So you think about Mr. Dekar next time.
Second chance, my lord, my lord.
because permit,
The
petition.
first chance has already been given, my lord, to Mr. Learned Senior Counsel.
Huh?
The first chance already been offered by this.
But it is not last chance, my lord, it's the first one.
I told you to make a submission before that there was this counsel out there, he didn't know anything that there was a requirement of submission of evidence. And this is very, this is you, without the evidence, how do you prove 150 this fraud? I think we can finish it off now itself. You have not yet used the evidence.
If you permit, then my lord, I file it.
The respondent filed an application
for setting aside the ex parte decree along with the delay condemnation application that was allowed against which the present revision is filed. Page number 54 is the my execution case was also dismissed. My execution case, their application was allowed and my execution case was dismissed.
Obviously,
Worship, they entirely.
once an application under order 9 rule 13 is allowed, the decree becomes useless.
The trial court ordered them state the execution.
No, there's no decree.
Worship, what I submit, they only blame the advocate in the application.
That is a different thing. But the execution of there cannot be a title execution proceedings taking into account there is no decree.
I agree.
Now coming to the other thing, they filed their written statement on 10/5/2022.
Contested till 10/5/2020.
On all the dates till 10/5/2022, when the case was fixed for filing of additional written
Additional-
statement. Then within 2 dates, suit decreed,
It was decreed on 2/7/2020.
2 dates.
Yes, sir.
How?
I filed my evidence and the ex parte decree was filed.
Oh, is it fixed for hearing?
No.
Right? Execution petition dismissed where? Order?
Last page.
Rightly
68.
so. When the decree is not there. Hello. Heard Mr. G. Bhardwaj, the learned counsel appearing on behalf of the petitioner. And Mr.
M. Khanial.
So and so appearing on behalf of the respondent. 115,
226.
the supervisory jurisdiction of this court have been invoked to challenge the orders dated 27/8/2024 passed in Mizze case number 50/2023, as well as the order of the same date dated, as well as in title execution case number 02/2023. It is seen from a perusal of the materials on record that a suit was filed by the petitioners as plaintiffs, which was registered and numbered as title suit number 5/2017. After summons were issued, the respondent herein, who were the defendants, how many respondents?
Two
The respondents herein, who were the defendants, appeared before the learned trial court and filed their written objection a written statement as well as counterclaim. Full stop. Thereupon, the suit was fixed on 10/5/2022, on which date the counsel appearing on behalf of the petitioners herein, the plaintiff, sought for time to file the additional written statement. The said prayer was allowed. Full stop. And the court fixed the matter on 27/5/2022 for filing of the additional written statement. Full stop. On the said date, as the respondents herein, who were the defendants, did not appear, the court passed an order to proceed ex parte against them. Full stop. Thereupon, on 22/7/2022, the learned trial court decreed the suit in favor of the petitioners, oblique the plaintiffs. Full stop. It is further seen that pursuant to the decree passed on 2/7/2022, entitled suit number 5/2017, an execution application was filed in the year 2023 by the petitioners herein, which was registered and numbered as title execution case number 02/2023. Full stop. Upon receipt of the notice in the said execution proceedings, the respondents herein filed an application under Order 9, Rule 13, along with
Delay condonation.
an application for delay condonation. The said application was allowed by the learned trial court by an order dated, the said application was registered and numbered as Ms. J case number 50/2023. The learned trial court by an order dated 27/8/2024 allowed the said application under Order 9, Rule 13, thereby setting aside the judgment and decree dated 2/7/2022. Full stop. The consequential effect of setting aside the judgment and decree dated 2/7/2022 was that the execution proceedings cannot survive, for which a consequential order was passed in title execution case number 2/2023, whereby the execution proceedings were also dismissed. Full stop. Under such circumstances, the petitioners, who were the plaintiffs, oblique the decree holders, have approached this court by filing the instant application under Article 227 of the Constitution. Full stop. This court have duly taken note the reasons so assigned, that this court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the order dated, impugned order dated 27/8/2024, passed in Ms. J case number 50/2023. Full stop. This court is shocked and surprised to take note of that without that on 27/5/2022, the judgment and the additional written statement was filed by the plaintiffs against the counterclaim. Thereupon, no date was fixed for filing of the written for framing of issues or issues framed
Not fair.
for framing of issues or further proceedings with the suit, but the learned trial court had decreed the suit on by the judgment and decree dated 2/7/2022. Full stop. This aspect of the matter was duly noticed by the learned trial court while adjudicating the application under Order 9, Rule 13, as would appear from the reasons so assigned by the learned trial court in its order dated 27/8/2024. Full stop. The reasons so assigned in the opinion of this court is just and proper, for which the question of interference with the order dated 27/8/2024 in Mizze case number 50/2023 arising out of title suit number 5/2017 do not call for any interference. Further to that, taking into account that there being a no decree, the question of the execution proceedings to remain does not arise. Full stop. Accordingly, the consequential order passed on 27/8/2024, thereby dismissing the title execution application being number 2/2023, do not call for any interference. Accordingly, this court finds no ground to interfere in exercise of its supervisory jurisdiction, for which the instant petition stands dismissed. Full stop. This court further takes note of that by an order dated 6/12/2024, the further proceedings of title suit number 5/2017 pending before the learned trial court, আগতে কৈছো নহয়, civil judge, senior division, Goalpara, shall is vacated and the parties herein being duly represented are directed to appear before the learned trial court on 6th of June 2025 for further proceedings of the said suit. So it is, however, observed that the observations so made herein shall not affect either of the parties in the trial of the suit.
The trial court record has been
The trial court records be forthwith returned. Oh, Dr. Ismailo, ahi, one ahi. Did you file edition in the WS? No. You even did not file it also. Hmm. No issues framed. How is it possible? My goodness. Trial court records be forthwith sent by the by the registry to the court below. It's 6. 6 Nokori. We directed on 6, na?
Yes.
6 Nokori, it will be on 16th of June. So the trial court records be forthwith sent by the registry before be remitted by the registry, ensuring that the said records are available before the learned trial court on the date so fixed herein above. In that regard, the registry shall also, in that regard, if necessary, the registry shall employ the services of a special messenger.
Hello. Obliged.
22.
Lordship, this is an revision application, my lord, against an order dated 21/8/2024. Impugn order is at page 57, my lord.
Challenging which order?
My lord, the order of the review, my lord.
How? Review allowed?
No, review has been not allowed.
Then you're not challenging the original order?
No, my lord, but
Then
I had filed one application for additional, allowing additional evidence in title appeal, my lord. I, being the plaintiff, had filed one suit, my lord, for declaration and recovery of possession.
Mr. Counsel, tell me
Yes, ma'am.
how a review order, the moment it is dismissed, a review petition is dismissed, you have to challenge the original order.
No, my lord.
Isn't that the
review-
law? Isn't that the law? Order. If the review would have been allowed, then the question is different. Review has been partly allowed, the question is different. But you need to actually challenge the order of 1310. Without challenging 1310, how can you do so?
My lord, 1310 order, my lord, it was partly allowed.
Partly allowed, fully allowed, I'm not on that. You filed a review against the 1310 order.
Yes.
Your review petition was dismissed.
Yes.
So if that so review petition dismissal order cannot be challenged here. You have to challenge the original order because there is a merger. That is the scope and ambit of order 47. Kindly look into that.
Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by a decision or a reference from a court of small causes, and who, from the discovery of new and important matter of evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was
An
passed.
order of the court rejecting the application shall not be appealable, but an order granting an application may be objected to at once by an appeal from an order granting the application or in an appeal from the decree or order passed. 47(7). There's a bar. Because it cannot be. So therefore, once your review application is dismissed, the original order comes into the being. So you cannot exercise the power that this court should look into it, that he did not exercise his review jurisdiction properly or not. But the power of review jurisdiction is given to that court. Now, just for example, I allow your petition. I can only say that he exercised his review jurisdiction wrongly. Then what happens? I can only allow that, but your order of 1310 remains. So you have to challenge 1310 also.
By way of an appeal, my lord.
No. Whether it is appealable.
No, my lord.
So you have to file under 227. You have to challenge that also.
My lord, I do the necessary correction. I'll do the, my lord, I'll withdraw this and then liberty to file a fresh revision.
You challenge both the orders, whatever may be, as a matter of abandoned caution, but without challenging 13.3, you cannot. The learned Mr. K.R. Bolwar, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to withdraw the instant application, taking into account that erroneously the order which was thought to be reviewed have not been challenged. So taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the petitioner to challenge the order dated 13/10/2023, passed entitled Appeal number 5/2022 by the learned civil judge senior division Karbi Anglong Dipu, along with the order by which the review application was rejected. Full stop. It is further observed that the period from 3/1/2025 be till date be excluded while computing the period of limitation. Interim orders, if any, stands vacated. What are you challenging?
The involvement
Ground
of
of
vehicle as well
objection?
as quantum.
Huh?
Involvement of the vehicle as well as quantum.
Involvement of?
The vehicle, insured vehicle. As well as the quantum of compensation under certain.
Okay, what is
It's
the
an injury
involvement
case.
of vehicle?
That's what has happened in this case. There is a GD entry 315-316 of 23/2/2022.
Hmm.
In which case, the police had gone to the spot.
Hmm.
They heard that there is an accident and they also sent the NGO to the hospital and seized the motorcycle. According to the lordship inquiry they made on the spot, an unknown truck had hit the vehicle.
Hmm.
The same police officer, lordship, when they say, after 6 months, another GD entry was accepted, lordship.
Hmm.
In which case, the different motorcycle because was shown to be involved that had hit the injured person who was supposed to be a pedestrian.
Hmm.
Accordingly, case proceeded, and the insurance company had called the police officer. It turned out the same person had written this GD entry. 6 months later, he recorded under GD entry. And then proceeded without any explanation. Why was that person vehicle seized? Entirely different numbers.
So if it is your default, the truck on which the truck was insured with you.
There's some unknown vehicle had.
No, that I understand.
Yes.
Now, this is being given to you for what truck?
The truck
Which
is not
vehicle
known
is
to-
insured to
The
you?
Another motorcycle is shown to be involved, and here that motorcycle had hit the injured person and ran away. That doesn't explain why the other motorcycle was found on the spot. And
Now
was seized by the vehicle.
you are an insurance company.
Insurance
Your
company.
insurance
Second
company
vehicle.
is for which vehicle?
Second vehicle.
Which one?
Thing is implanted.
For implanted.
What is happened, Asif? I'll just say it out, one part of the yes. On 23/2022,
Ah.
that one motorcycle is numbered 4939. Motorcycle এখন অচিনাক্ত ট্রাকে খুন্দিয়াই থৈ যোৱাৰ ফলত দুৰ্ঘটনা সংঘটিত হয়. They brought the also motorcycle in the
Hmm.
Then subsequently, lordship, the same police officer
Hmm.
on 22/8/2022. Everything is overwritten also.
Hmm.
Then another motorcycle, this number is entirely different, 7711.
That's
Had
the
knocked
bullet.
This person,
That's the bullet.
had knocked this person who was injured.
Okay.
So that does not explain, and 6 months later, so 6 months, FIR is filed, it's in any case doubtful, lordship, manipulated, and plus it does not explain the vital, like why was the other motorcycle found on the spot?
No, you are the insurance company of which vehicle?
Second
Okay, you hit whom? The claimant.
person, Claimant.
Okay, so they now say that this vehicle, the bullet had hit that vehicle. That is what the finding of the learned tribunal is concerned.
My vehicle had injured the claimant.
That is what. But
my-
actually, that is not some other, it was a truck.
First, GD entries has more credibility because they have gone to the spot, found that motorcycle, the distinct number is there.
Heard Mr. R. Goswami, the learned counsel appearing on behalf of the appellant. Is an appeal filed under section 173 of the Motor Vehicles Act 1988. You are for all?
Claimant.
Okay. You don't get any money.
Lordship,
And I'll state. Because it's a question of whether it is true or false.
Lordship, kindly see, this is the observation in para
No,
31 maybe.
That has to be adjudicated upon. We'll
Lordship.
see the records and look. at
Police
it.
after completion of investigation filed charge sheet and charge sheet remain unchallenged, lordship, till date. And during the trial, lordship, the police investigation officer was examined. Lordship, this statement may be seen, lordship, para 31.
Where?
Para 31, page 22.
Para 31.
Yes, lordship. Para 31 onward, lordship, it is clarified.
Yes. This is a death case.
No, amputation. Above knee amputation, Lordship. And para 36 clarified, Lord.
But why there is no FIR file for 181 days?
Lordship, he was injured, Lordship. He was in hospital, Lordship.
There was
Suffering with
nobody
father.
else.
Lordship,
There was nobody else to file an FIR?
not fine, Lordship. He was busy in treatment, Lordship.
What has happened to you?
Father was there, Lordship. His father,
Huh?
his father was there. He said, my father is the owner of the Activa, one Activa scooty. So his father was there. He might have a name, but his father was there to file the.
This was subsequently charge-sheeted, Lordship.
Charge sheet is only an opinion. That is not final.
Yes.
We stay till the trial court sends the owner to the vehicle jail. Huh? Till the jail.
Above knee amputation, Lordship. He's a 25 year.
Help it.
Lordship, we are ready to, Lordship, executing bond, Lordship. 50% may be released, Lordship. Para 36 clear, Lordship. Evidence of the DW2 is the investigation officer of the case. Para 36.
Out of 34 lakhs, only 6 lakhs is given to be put in the FDR. What is wrong with the judge? Huh? Is it ever heard of?
Claimant is a bestseller.
So he needs the money for what?
For treatment, Lordship, or other things.
He's already spent the money. For treatment, you have spent only 3 lakhs.
Above knee amputations, Lordship, on file, Lordship. So he become unemployed.
Medical expenditure was 21,000.
Huh?
Medical expenditure 21,114.
That is what I'm saying. No, there is an appeal under section 173 of the Motor Vehicles Act 1988, challenging the judgment award dated 8/8/2024, passed in MHC case number 1365/2022, whereby an amount of rupees 34 lakhs 51,372 along with interest at the rate of 9% per annum have been directed to be paid by the appellant insurance company. Full stop. Mr. R. Goswami submits that there are 2 grounds of objection taken in the instant appeal. First, the identity of the vehicle in question is an issue, taking into account that there were 2 GD entries. One entry referred to another motorcycle, whereas the second entry, but one entry is for motor truck, was in respect to an unidentified truck, whereas the second entry pertains to a motorcycle, of the motorcycle in question being AS
04887711.
AS 04887711. The learned counsel further submits that neither the driver nor the owner of the motorcycle have appeared before the learned tribunal and have adduced evidence. Full stop. The second ground is on the question of quantum. he submits he submits that the amount which have been awarded is shockingly disproportionate. First, taking into account the two grounds of objection, the instant appeal is admitted. Call for the records. First, Mr. So-and-so appears on behalf of the respondent number one, and as such, there is no requirement of taking any steps against the respondent number one. However, an extra copy of the memo of appeal will be served upon him along within 2 days. As regards the respondent number 2 and 3, steps be taken by way of registered as usual. Call for the records to लिख लियो ना? चलो, I can लिख लो. This is an application for under Order 41, Rule 5 of the Code of Civil Procedure for stay of the judgment and award dated 8/8/2024 passed by the learned member MACT 2 Kamrup Metro in MAC case number 1365/2022. First, Mr. R. Goswami, the learned counsel, for remand for stay of the judgment and award dated 8/8/2024 passed by the learned member MACT 2 Kamrup in MAC case number 1360 of 2000. The learned counsel appearing on behalf of the appellant submits that the entire judgment and award is required to be stayed, taking into account that the petitioner herein, taking into account that the appellant herein would not be liable if the first ground of objection is proved before this court. The learned counsel appearing on behalf of the claimant has objected to the said and submits that he would file objection. First, taking into account the above, list this application again on 4th of June 2025. In the meantime, an objection be filed. In the meantime, liberty given to the respondent number one to file objection. Till the next date, the operation of the judgment and award dated so and so shall remain stayed. Next.
25.
Yes.
The deceased was a government employee, my lord. And the evidence of the official witness testifies that his case was covered under the compassionate family pension scheme. Lordship, may kindly see page number 19.
Issue. There is an appeal filed under section 173 of the Motor Vehicles Act, challenging the judgment and award dated 4/2/2025, passed in MSC case number 2328 of 2021 by the Motor Accidents Claims Tribunal number 2 Kamrup Metro at Guwahati, whereby an amount of rupees 64,05,897 was awarded along with interest at the rate of 9% per annum from the date of filing of the case, that is 30/12/2021. First, the learned counsel appearing on behalf of the appellant submitted that taking into account that the person concerned, the deceased concerned had expired, had died in harness while serving as an officer, serving as an assistant teacher,
Assistant teacher.
assistant teacher, assistant teacher,
Okay.
the
Kusaboy
person,
LP School.
huh?
Kusaboy LP School, Hajo.
At
Kusaboy, KUSHABOI. Page 17, Lordship, para 22.
page 17.
Para 22.
Was functioning as a head teacher.
Assistant teacher.
Are you sure?
Yes.
She might have been promoted to the position. Okay. As an assistant teacher of Kusaboy LP School, Hajo, he would be entitled to the benefits under the provisions of the, what is that?
Compassionate Family Pension Scheme, 2017.
17 of the government of Assam. And this very aspect was not taken into consideration while passing the judgment and award passed by the learned tribunal. Taking into account the above, taking into account the said grounds of objection, the appeal is admitted, call for the record, steps be taken by way of registered as well as usual. Stay on the. There is an application filed under Order 41, Rule 5 of the Code of Civil Procedure for staying the judgment and award dated 4/2/2025 passed by the learned member Motor Accidents Claims Tribunal number 2, Kamrup Metro at Guwahati in MSC case number 2328/2021, whereby an amount of rupees 64,05,897.60 was awarded in favor of the claimants. Full stop. Issue notice making it returnable on 2nd of June 2025 on 16th of June 2025. Steps be taken by way of registered as well as usual. Full stop. This court, taking into account the ground of objection and the fact that the accompanying appeal has been admitted, stays the instant proceedings, stays the judgment and award till the next date. Judgment and award dated 4/2/2025 till the next date, subject to deposit of an amount of rupees 1,88,632 before the registry of this court on or before 16th of June 2025.
26.
That is the conventional one I have allowed, along with the medical. Oh, yes. What is this? Enhancement.
No, your lordship, my claim has been dismissed.
Okay. Why?
Your lordship, the finding of the court is that the accident took place due to my fault. Whereas the case has been charge sheeted against the driver of the offending vehicle. The driver was examined by the insurance company.
Is an appeal filed under 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 27/11/2024, whereby the claim proceedings being MAC case number 650/2021 was dismissed by the learned member Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati. Full stop. The learned counsel appearing on behalf of the appellant submits that the learned tribunal have failed to take into account the evidence on record to show record to the effect that there was a rash and negligent driving of the vehicle, which have resulted into the death.
No, yeah, I am the injured.
Injury of the claimant, of the appellant. Full stop. Further to that, the learned counsel further submitted that the learned tribunal have also decided the said proceedings in a manner in which our criminal proceedings is to be adjudicated, and not in the manner and by which proceedings for claims compensation for under the Motor Vehicles Act 1988 is required to be adjudicated. Taking into account the said grounds of objection, the instant appeal stands admitted. Call for the record, stamps be taken up, registered as well as usual upon the respondents.
Obliged.
27. Under the compassionate family pension scheme.
Huh?
The case under the family, compassionate family pension scheme.
Compassionate family pension, no?
This is as a government employee. Instead of relying upon Reliance versus Sesi Sharma, the learner member has relied upon National versus Sebastian Laka. That is again a different scheme altogether.
Okay, এইটো একে order হ'ব। হা, সেই এটা যে এইমাত্ৰ order এটা দিছিলো, কি কৰিল তাৰ? কি কৰিল তাৰ আছিল? Stay কৰিলো, subject to deposit of 1,65,88,000 কৰিল না? This is subject to stay a deposit of rupees 2,99,900. Putting it same on the same date on 16th of June. You deposit on or before 16th of June, 2,99,000. This is stays to that.
Item 28 to 30, hearing under Order 41, Rule 11 CPC.
Yes, what is this?
I am in this thing, 60 of 2024.
Ah,
I am one of the applicants.
you are
I am for the applicant in RSS 60 of 2020,
60 of 2014.
Uh,
Here it has not been admitted.
24,
Huh?
24.
This is not admitted till now. Who is appealing for RSC 24? 60 oblique to 2024.
I am for the respondent.
Huh?
I am for the
Okay.
respondent.
There is,
Why you are on caveat?
No, my lord, I have preferred the second appeal to, that is item number, RSA number 211 of 2018.
Now, Alveda, what is the case about?
My lord, that RSA 2011, the suit.
This can't be said to be a question of law.
My suit was dismissed only on the ground that my lord, his lordship will take page 48 of my appeal.
Your appeal.
Yes, 211.
Yes.
Paragraph 17.
What is the suit for?
Suit for declaration of right title interest
And
and for recovery
and
and for cancellation of revenue records as well as mandatory injunction for demolition of building that was amended after during the pendency of the suit
then
and for eviction of the defendants.
so both are dismissed.
No, my lord. In the trial court, in trial, the suit was decreed and the claim filed by the
Was
appellant
dismissed.
were dismissed. And in a first appellate court, dismissed the suit filed by the appellant here and dismissed the counterclaim.
So both are dismissed.
Yes, both are dismissed.
That is what. Then
First appellate court. I have preferred this first appeal, second appeal 2011, and now this 60 of 2024 has been preferred by the counterclaimant, which has not been executed.
My lord, in the meantime, the present, the respondent of this RSA, that is the appellants of the RSA 211, they instituted a suit, 117 of 2081, 1981. That suit has been dismissed, but there is no whisper about it. In the entire memo of appeal that they have preferred, there is no whisper.
I'm not on, I'm asking you,
My lord.
what is your points for determination? Yeah,
My point
substantial
is
question of law.
that, my lord, that so far as the plot of land is concerned, it is, we are in possession and we have not encroached anything. And the appellant, that is the plaintiff, he himself during his cross-examination, he stated, I do not know what is the length and breadth of my, this thing, plot of land.
What
My
is your counterclaim for?
My counterclaim was, if Lordship kindly peruse, RSS 60 of 2024, it is at page number 35.
Your counterclaim is that the suit should be dismissed.
No, my lord, in item, this RSS 16, the counterclaim is there at page 35.
60, RSS 60 of 2020.
No, you have the copy of 211?
211,
Here only the written statement has been.
No, you say of the written statement and counterclaim of the defend number 126,
Why not the
page
counterclaim?
16.
16 is the, it's mentioned, but there is separate counterclaim.
Where is that?
It's in RSL number 60 of 2020.
We have not enclosed.
I have not enclosed.
So on that ground, we should dismiss your appeal. Deficient pleadings. Okay.
That
Let
was
us
filed
see.
separately, my lord, counterclaim.
We should dismiss your appeal. Where is the counterclaim?
counterclaim is at RSS 60 of 2024, it is at
Page
page number
35.
35.
Huh? Counterclaim. Decree for recovery of possession of the property mentioned in Schedule X. Decree for declaration comply has inventory right to enjoy the drain service so and so. Decree for removal of the obstruction to appear for compensation of mean profit for the period from Iman onwards from the opposite party plaintiff. What is your right over the land?
Right over the land is, my lord, it is our paternal property. And the present plaintiff, original plaintiff, is my uncle. And my father and both my uncle, they were the two brothers. So for the record book.
Portion of the land and house measuring 3 feet. Northern and southern 38 feet. So he is in possession of your land.
Partly
And,
yes.
and concurrently, it has been held that you could not prove anything.
My lord, I have adduced my evidence as a DW1, because evidence was adduced. And that evidence is not at all considered.
So,
That is why I have to come up with this. Their suit has been rightly dismissed because they could not prove anything. Even the plaintiff does not know what is his land, what is his area. He doesn't know. The plaintiff, original plaintiff.
your decree is on the basis of a
On the basis of a
sale deed.
declaration, no, my lord. of a declaration, of a decree passed in a suit of 1961, whereby a earlier partition deed was cancelled, and it was admitted that it was in execution in 1971. The suit land was handed over to us
On the basis of partition,
on the basis of partition
meaning thereby you get your right from somewhere.
from title suit.
No, no. Title suit cannot give you a title.
Yes, it was a
Title
joint
suit can
property.
only adjudicate your title.
Yes.
So in the
Nobody can
partition
do it.
proceedings, it was granted to you.
Yes. And they have admitted, the defendant witnesses admitted that this was what the portion we are,
Record, I say. Record.
it was earlier fixed for hearing. Our second appeal was fixed for hearing.
List the appeal. It RSA to the list the instant appeal on 17th of June 2025 at 2 p.m. in the column of order 41 rule to 11. Pustak. Econo দিব RSA 211 লিখিব list the instant appeal for hearing on 17th of June 2011 to 25. The registry shall ensure that the LCR which were called for by this court on 30/7/2018 is available when the matter is taken up for hearing. And what is this CRPIO?
CRP, against an injunction order was declined by the first appellate court also. Against that, this CRP was.
You have come.
Yes.
Then,
It was also tagged with this 211.
no, now there is nothing here.
That's it.
We close this.
Well, Lordship can put it along with the.
Why? As of now, there is no suit, there is no first appeal. We are in second appeal. You want an injunction, that injunction has to be in only an RSA.
It is against the violation. It is against the violation that CRP,
What?
against the violation of the injunction order.
So this misappeal is filed by whom?
The plaintiff. Plaintiff, you might say.
Nothing remains. It is dismissed. What are we going to do with the violation now? Mr. Adhar, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant petition, taking into account the pendency of the RSA number 211, public 2018, which is pending before the court. Accordingly, this instant application stands closed. The withdrawal of the instant petition shall however not affect the rights of the parties in pending in RSA number 211 of the 2000.
Supplementary item 60.
None appears on behalf of the appellant on call. This is the matter after 2 weeks.
Same matters item 51.
Met with the lot.
Hmm.
Well, this thing here is under land grabbing act, my lord. The special court principally has arrived at a perverse finding and held that I am a land grabber. Well, against that, I have filed this revision petition, my lord, before you. My lord, lordship has granted stay of the impugn order and it has come on the returnable date. LCR called for is not the statement. LCR in this case called for, my lord, LCR is not the statement.
We have to admit this. Not dispose it like this, but we fix a date for hearing. So taking into account that instant proceedings, by the way of the instant proceedings, the judgment and decree dated 26/7/2024, passed by the learned presiding officer, special tribunal, land grabbing in Sukia, in LG case number 5/2023 has been put to challenge. Full stop. The respondents are duly represented.
For one,
With the others.
who is, my lord, the state of Assam Revenue Department?
So they this matter for final disposal on 15th of July 2025. Pusto. The interim order passed earlier shall continue till the next date. Pusto. The registry shall also ensure that the records of the learned tribunal is available on the next date.
52.
This case matter is very short. I am the plaintiff in the suit. Then the suit is pending at the stage of framing of issue. Suit is pending at the framing of issue. It has not been yet framed. In that case, the defendant number 5, the respondent number 4.
What is the order you are challenging?
At page 89.
Huh?
At page 89.
In petition number filed by plaintiff
My
wherein
only
it stated
concern
the
is that
petition
I
on
have
the
put-
order herein has been filed by the plaintiff and is not allowed the plaintiff. Petition filed by the heir on the heir shall be rendered infructuous and is free for constitution with and all year. But let me respect the non-council is free for constitution with the and the. That's free for constitution. Now you wanted to amend.
Amendment.
They
Amendment.
filed a petition for preliminary, say on
Amendment
preliminary.
is sort of that, actually suit is filed for partition and cancellation of sale deed of the subsequent purchasers. Now I do not want to place the partition prior lordship. Therefore, I have to file a petition. It is actually abandonment of claim. There is a provision under order 23 rule 1. So my submission is that my decision of my petition has bearing on the decision of the other petition. So therefore, my petition may be taken up first or together. The learned trial court has dismissed my petition, dismissed the trial. And the case is that lordship, a order has been passed to file a bis case. But till now, no bis case has been filed in regard to my petition, lordship.
Lordship, kindly see. We have filed a petition because this suit is for partial partition. So on that preliminary issue to be framed, that petition we have filed. They take time for filing objection. They did not file objection, but they filed one petition, lordship.
But Mr. Decker, tell me one thing.
Yes.
Issues are to be framed on the basis of pleadings. Preliminary issues is also to be framed after the pleadings are over. Isn't it? So if that be so, if he wants to amend the pleadings, how is it, how does it affect you?
Lordship, we have filed our draft issues. And this petition, preliminary issues petition is pending. They filed their petition. Now, what is the petition they have filed and the order is passed? They filed a petition to kept in abeyance our miscase.
Huh.
And what is the purpose of this miscase? To make our case infructuous. Lordship, kindly see the page 85.
No, your case is not infructuous. Your petition may become infructuous.
That is
So
But-
if he wants to withdraw the prayer for partition, he has, the plaintiff can do so at any point of
At any
time.
point.
That is the law under order
Yes,
23 rule 1.
that is also in our, go in our favor, Lordship, proviso to section 34 is there.
Hmm.
That
You
is-
can very well take that.
But Lordship, thing is that both this petition is pending before the court. So they could have approached because their
Oh,
case,
they have been now better advised. They've got Mr. D. Colita in their side now. So,
thing is that Lordship,
order is there to register a miscase. If miscase is not registered, the bench.
No,
is-
no, no,
is a-
let the order 6 rule 17, let the court decide, may reject or whatever,
Yes,
then
yes.
also your
I
14
don't
can
have
do.
any
Your
problem there.
14 2 does not, if it becomes infructuous, one, it is good, one stone, two aims.
By proviso itself it will go.
Okay, very well. देखो, heard Mr. D.K. Kolta, D.K. Kolta, D. Kolta Lalan Counsel appearing on behalf of the petitioner, Mr. J. Deka appears on behalf of the respondent.
Respondent number 4, Lordship.
The instant application has been filed challenging the order dated 13/12/2023 passed in Title Suit number 82/2021, whereby the learned trial court, that is the Court of the Civil Judge Senior Division Kamrup at Amingam, had passed an order, had rejected the request made by the plaintiffs, which the public, the petitioners herein, for taking up the application under Order 6, Rule 17, prior to deciding the application filed under Order 14, Rule 2, which have been registered and numbered as case number 145/2023. First off, this court have duly taken note of that issues are required to be filed on the basis of the pleadings. First off, the preliminary issues are also required to be filed, is also to be adjudicated on the basis of the pleadings, and more particularly taking into account that the contents of the pleadings of the plaintiff are sacrosanct. Taking into account the above, this court is of the opinion that the learned trial court ought to have decided the application under Order 6, Rule 17 prior to a decision being taken in respect to the application under Order 14, Rule 2, in as much as any decision taken in an application under Order 14, Rule 2 may render prior to a decision in an application under Order 6, Rule 17 may lead to multiplicity of proceedings. Considering the above, this court interferes with the order dated 13/12/2023 and directs the learned trial court, that is the Court of the Civil Judge Senior Division Kamrup, to decide the application under Order 6, Rule 17 of the code filed by the petitioners oblique the plaintiffs prior to the decision, prior to the any decision is taken in case number 145/2023. With the above, the instant proceedings stands disposed, taking into account that both the parties are duly represented, disposed, the interim order passed on 27/5/2024 is vacated. Taking into account that both the parties are duly represented, they are directed to appear before the learned trial court on 6th of June 2025 for further proceedings of the suit. You inform your family members.
No, all separate procedure.
It is seen, however, that some of the respondents are not before this court. So the learned trial court shall proceed with the years by also informing the counsel who represents the state respondents oblique the defendants before the learned trial court.
Lordship, Lord Court date is on 30/6/2005 for necessary order. 306 June, 30 June.
6.
53.
And let it be on, I fixed on 2/6.
6.
No, 2/6 karo. 2/6 karo for appearance, because then 36 ho jabo.
Yes. Obligation.
Yes, Mr. Upadhyay.
May I please?
Ah,
I'm sorry to state that I've implemented respondent number 3 to 10. They are not the necessary party, Your Worship. And
And the service to the respondent number 2 is yet to be completed, Your Lord. Service to the respondent number 2 is yet to be completed,
Service is complete.
not completed.
Not necessary, we dismiss your suit proceedings. You have earlier sought
Yes.
for amendment,
Yes,
amendment done,
done.
matter has now proceeded to the position, stage of PW. Then why on earth you did not file this application earlier? And the court is right.
Here due to the lack of communication, Your Lordship. And earlier, the council is different. And when the new council come, he's seen that there is some mistake. Typographical
Huh?
mistake, Your Lordship. Typographical mistake, Your Lordship. Only,
You are appearing for?
I am for the respondent number 1, Lordship.
Okay. Others,
Others, I do not have any.
where is the plaint?
plain is page 15, Your Lordship.
Others are performer, we are not concerned.
Performer, yes. But the 2 is there. Your Lordship.
Where is he? I'm not as you have not taken steps, no more. Can't help
No,
it.
we have taken this step.
No, you could not affect service upon respond number 2, I can't help it. It's okay, service complete.
May I please, Your Lordship? Lordship, the
Hard
suit was
mistake.
instituted in the.
No, no, no. You see, this amendment would not change anything. You make him correct, you file your written statement.
No, my Lordship, I'm submitting Lordship. Lordship, the suit was instituted in the year 2015, and it took them almost 1 decade to clarify, amend the claim. On the other hand, in the year 2019, they have filed an amendment petition, and which was accordingly allowed. And that too, after the commencement of the trial, Lordship. During that period of time, the trial was progressed to the stage of evidence of the PWs. And again, it is now in the year 2024, they have come up with another application. May I read out the paragraph number 5 of their application, Lordship, at page number 8, Lordship.
No, I'm dismissing his petition.
Yes.
Wait. There's not a single word about your due diligence. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so who appears on behalf of the respondent number 1. None has appeared on behalf of the respondent number 2. As regards the performer respondents, no steps were taken by the petition in spite of obtaining a stay order from this court. Be that as it may, the petition instant proceedings have been challenged by filed challenging an order dated 27/5/2024 passed in Milje case number 166 of 2003, whereby an application filed under order 6 rule 17 of the code for amendment of the plaint was rejected. This court had duly taken note of the impugned order, duly taken note of the application filed under order 6 rule 17 by the petitioner who were the plaintiffs, as well as the impugned order. First of all, it is relevant to take note of that the suit is at the stage of trial. First of all, it is relevant to take note of that the trial of title suit number 84/2021 have already commenced. It is also relevant to take note of that on earlier occasion, another application was filed by the petitioner seeking amendment which was allowed, that too at a stage where the trial had commenced. This is the second application filed seeking amendment of the plaint. There is not a single whisper in the said application as regards the due diligence as to why this application could not be filed earlier. Full stop. Taking into account the above, this court finds no ground to interfere with the order dated 27/5/2024, passed in media case number 166/2023. Accordingly, the instant petition stands dismissed. Full stop. The stay order dated 8/2024, passed by this court, is vacated. Full stop. Parties are directed to appear before the learned trial court on 2nd June 2025 for further proceedings of the suit.
Item 54.
Yes, madam.
My item, my lord, I will be excused.
Is the challenge?
I'm not feeling well, my lord, I am.
Not
tired.
necessary. I'll help you out.
Next week, my lord.
Yeah, my code, not necessary for making too much of argument. Don't worry. Impugn order dated so and so passed by the, yeah, where is that impugn order? 6/5/2024, so and so issues of claim. It appears that so and so claiming in that regard demand and limiting the right of the demand by this time the new amendment has been done.
Not 54. Is it 55? Mine is 55, my lord, not 55, not 55.
Any accident of course, of course, to be done to be done.
In a 54, I am here.
Ah, yes.
I am here.
Which item? Okay, 55. Next item. 55 is which item? Next item. Okay, let us take that item 55 first. Yes, what is this?
Lord,
What's that?
the petitioner before Lordship is the defendant number 4 in a suit, my lord, instituted by the opposite party plaintiff for declaration that the mutation obtained by the defendant number 4 in collusion with the revenue officials is illegal, void ab initio, on the strength of without any legal document, mutation was obtained.
Where is the order?
Order Annexure 6, my lord,
Page
page 49, my lord,
49.
49.
Today is the
My
date
lord,
fixed
in
for
fact,
remand
I-
filed by the for the defendant under order 6 with the fair trial of the defendant to examine the nature of mutation. What is wrong with that order?
My lord,
What is wrong with the order? What is wrong with the order?
order 26, rule 10A,
Who filed it?
my lord,
Who filed it?
defendant.
No. Who filed it? The advocate.
My lord, today I am not feeling well at all.
No, don't worry. You take your seat. Let me dismiss it.
My lord, I won't be able to.
Yes,
get
Miss
position,
P.
my
Bachchan.
lord.
Lordship, order is rightly passed, Lordship. This is a Kacha sale deed, Lordship.
Huh?
This is a Kacha sale deed, Lordship. He want to send the signature for examination. only.
Understood, but who wants it?
Defendant number 4.
No. It is
Yes.
filed by the advocate.
Yes, sir, filed by the advocate.
What business does the advocate have?
Petition filed by the defendant, my lord. Verification is by the defendant, my lord.
Page
Two-
43, Lordship.
Two
that
petitions
petition.
filed.
Page
Huh?
43.
One under order 26, rule 10A,
Page 43,
and
first petition.
one
Lordship.
under order
14 Rule 5, my lord, for framing two additional issues.
But the order says that on petition number so and so filed by the engaged advocate for the defendant. Huh?
Petition lordship that is filed by the defendant.
Defendant herself, my lord.
List this matter again on taking into account that Ms. B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that she is as inconvenienced. List this matter again on 21st of May 2025. Interim order passed earlier shall continue till then. Yes. Mr. Aegis.
54.
What are you challenging?
Lordship, service is complete, Lordship.
What are you challenging?
Lordship, that limitation point, Lordship. Accident took place prior to amendment. A similar order was passed by this honorable Lordship, rejecting my petition. Accident took place prior to amendment of 1/4/2022.
And then?
Then Lordship, we have filed that revision petition on the ground that the accident took place in the year 2016, but this was filed on Lordship 31/12/2022. That is-
FIR not filed.
Lordship,
FIR is not filed.
Lordship, we have no instruction.
You are the company, insurance company.
Lordship, yes. Lordship. Accident took place
Accident took place then.
in 2016.
Then
In similar cases, Lordship, our petition was rejected by Mr. Lordship, Honorable Justice Lordship Robin. Robin Fukan, Lordship, there is judgment. That the same.
you have the order.
Lordship, I have,
This type of petitions have been rejected, na?
yes, that is then prior to that amendment. But after amendment, that will sound ground.
Heard Mr. AJ Soikia, the learned counsel appearing on behalf of the petitioner. Full stop. This is an application filed under Article 227
Yes,
or
Lordship,
115.
227, Lordship.
227 of the Constitution challenging the order dated 6/5/2024 passed in MSC case number 196/2022, whereby the application filed by the petitioner seeking dismissal of the claim proceedings was rejected. Full stop. It is relevant to take note of that in the instant case, the accident took place on 27/4/2016, and the claim proceedings was filed on 31/12/2022. The learned tribunal, that is the Motor Accidents Claims Tribunal, Dhubri, by the order dated 6/5/2024, taking into account that the provisions of section 166(3) of the Motor Vehicles Act, which came into effect with effect from 1/4/2022, 22 from a year would only apply prospectively and not in respect to accidents which occurred earlier, had rejected the application filed by the petitioner. Full stop. This court duly takes note of that a coordinate bench of this court in the case of Sriram General Insurance Company Limited versus Mohammed Sadiq Hussain, CRP IO 427/2024, in a judgment dated 28/10/2024, held that the have upheld similar orders passed by the Motor Accidents Claims Tribunals, wherein it was held that in respect to accidents occurring prior to coming into force of Section 166(3) of the Motor Vehicles Act, the limitation provided in the newly inserted provision would not apply. Full stop. Taking into account the above, this court finds no merit in the instant petition. Accordingly, the instant petition stands dismissed, the interim order passed on 2/8/2024 passed by this court stands vacated, and the parties herein are directed to appear before the parties herein are directed to appear before the learned parties herein are directed to appear before the learned tribunal on 9th of June 2025. Full stop. It is, however, relevant to take note of that the claimants are not before this court in spite of service. Under such circumstances, the learned tribunal shall inform the claimant before proceeding with the said claim proceedings.
Item
Yes, Mr.
56.
Suntudio.
Production list, item 1.
Yes, what is this?
Yes. Very, what I will say, my lord, as thou said, under very peculiar circumstances, we approached this honorable court.
Yes.
What happened, my lord, is the landlord-tenant case. I am for the plaintiff. We filed this suit in 2015. Then it's continued for the last 10 years. In 2015, what happened, my lord? We have filed the suit. What you kindly see the list of dates. I have just prepared for that.
Now tell me, what are you challenging?
And now I'm challenging, my lord, that 7 days the plaintiffs were examined. His cross-examinations completed in 2024. It starts in 2018. Now it's completed. After completion of the evidence then the defense evidence has commenced. Now, after the 3 dates of the defense evidence, my lord, they filed an application for re-examination under 27 Rule 17. They have filed, the defendant, the tenant has filed an application under Order 27 Rule 17 for re-examination of which the courts has the power.
Order 18 Rule 17.
Yes. Then, my lord, that application was allowed. The context of the application was that a probate proceeding was filed by my mother, wherein this suit property was also included in the registered will by my grandfather. But during the lifetime of my grandfather, this suit property, along with others, that was gifted to us, this plaintiff, during the lifetime of the testator. Now, the probate proceeding was concluded, probate was granted in favor of my mother. Now, they filed an application saying that this is very relevant with this suit. So they have enclosed the judgment. They said that after the completion of the cross-examination of this plaintiff, that this judgment was passed. So therefore, it is irrelevant. So I am to re-examine the plaintiff again. Oh, my lord, that application was allowed. But in the order, the code also says that you cannot travel beyond the subject matter of this suit if it is relates to probate. The council has advised in the law code, my lord, that
Wait.
don't approach. Lordship, kindly have a look at
Which order?
that order we have not impugned before this law code.
Huh?
Yes, that order we have not challenged. We have challenged the subsequent order.
Which order?
So Lordship, kindly have a look at 109. Thirteen, my lord, kindly. 13 and 14
Ah.
is 111.
Then you are for the defendant.
I am for the plaintiff, my lord.
Then,
This is the defendant petition allowed.
then,
Then it's allowed, my lord. And 24 April 2025 was fixed for the cross examination.
Hmm.
Trial court specifically said no further adjournment. On 24/4, on a verbal prayer of the defendant, the case again refixed for the examination, my lord. I was present therein, page 113, my lord. This order also impugned. Then, my lord,
what happened on 3-5?
then on 3/5, my lord, I was cross-examined partly. And lordship is, apparently this entire cross-examination having no relevancy with the issues. The issue is defaulter. I objected. The council, before the trial court, also the PW1 objected against these exhibits. They exhibited the probate applications, they exhibited the judgment, etc., etc. And entire cross-examination relates to absolutely relates to the probate procedure, not with the subject matter of this. And on that day, on 3/5, they also filed an application for call for the death records of the probate proceeding. It will never end. So the learned trial court exercised the jurisdiction, my lord, which is not contemplated under this. That's my humble submission because the lordship kindly have a look into the entire proceeding, my lord. And therefore, there is no other alternative but to approach under Article 227. Now that petition has been fixed for the hearing on 6/6/2025, that call for the records. And then records, naturally, the court has
Where is that order?
last order,
Page?
page 150,
150?
150, NHA 50. 150. Where is the CP? I don't understand what CP is.
Let's see the petition under order 18 rule 17.
Lordship. One 102. 26/9/2020. And their application is very clear and pertinent. Only after the judgment, the subsequent events. Paragraph 5, kindly have 103.
So by way of the probate judgment, the land has been given now to whom?
So that not included in the subject matter of the land, my lord, of the suit property. That was in 2009 gifted to us.
But that is not a part of the.
Not, absolutely not. And it was been observed by the learned probate court also. So during the pendency, during the lifetime, the testator has executed the gift deed in favor of us. And it was not also disputed that they are not my tenant. They admitted, they deposited the rent in my name. In the WS, they have admitted the landlord-tenancy relationship. Issues were framed in 2019, my lord. The only issue is to be determined that whether the defaulter or not.
No. You should notice making it returnable on.
Lordship, my only prayer is being we are before this honorable court because 10 years already been passed. Lordship, kindly also appreciate our anxiety. So it's fixed on 6/6/2025, my lord. Our earnest request before this honorable court is that let the matter be disposed, not today, is absolutely not possible. Before 6/6, my lord, on the next day. We will serve the notice by the steam.
That is what I'm trying to do.
Yes.
You should notice making it returnable on 2nd of June 2025. Steps be taken upon the respondents. Numbers 1 to 5, 4, by way of registered as well as usual by Monday, date to review. Further to that, the petitioner is also directed to take steps upon the respondent numbers 1 to 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First, the petitioner herein have a sale.
Order dated 24/4/25, my lord, and 3/5/25.
What is 24/4
Adjournment, my lord.
and 3/5?
Yes.
Why you have not challenged the order of by which?
That's, we cannot, my lord, because it is very difficulty for me also to convince, my lord, because that we have already submitted for cross-examination. We appeared and for cross-examination. That's the problem. Otherwise, that order is also
I
bad in
have-
law.
The petitioner herein have approached this court. No, and again, have approached this court in the manner in which the suit proceedings, being titled suit number. What is the suit number?
Suit number is
37
37/15.
of 2015 have been proceeded with by the learned trial court. That is the court of the municipal civil judge,
Civil just 2, my lord.
civil judge junior division number 2. Upon exercising the powers under order 18 rule 17. First, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner submits that this is a case of gross abuse of the process of the court. And in order to delay the disposal of the suit, the respondents have resorted to actions which have no relevance, have resorted to tactics which have no relevance to the dispute involved in the suit. First, the learned counsel therefore submits that this is a case where the supervisory jurisdiction of this court ought to be exercised, taking into account the gross abuse of the process of the court. First, taking into account the above, this court would take up the matter again on 2nd of June 2025. First, and on the said date, this court would pass appropriate orders. First, the petitioner shall ensure that the service is duly completed on that date.
Grateful, my lord.
Yes, any more extension of interim orders?
My lord, in item number 44, my lord, there is an TP petition.
Eh?
In item number 44, my lord, it is under orders, my lord. The respondent side has already appeared. My interim order was. up
Yes,
to-
Mr. Dicky Panging, what are you doing here? I can't hear your voice.
My lord, I appear in for a respondent number 2 in item number 31.
What will happen? 31. 31 is, oh yeah. What is this?
My
Why
lord, the order was placed before the Honorable Chief Justice by order dated 24/2/2016.
Ah. For what?
This was regarding a controversy, my lord. At that time, my lord, no, the Civil Courts Act was not in place.
Ah.
So in terms of the Registrar General's case, whether the
Mm.
Deputy Commissioner could have continued to exercise appellate jurisdiction, my lord, against the decision of the village authority. That was deferred by Honorable Justice led Nisitendu Chaudhary, and that is how it came to be placed before Honorable Chief Justice. Now this issue has become redundant, my lord. The Civil Courts Act is placed now,
Because I remember one thing, I
my lord.
delivered one judgment. I forgot the name. Mr. Tara was there, Titi Tara,
Yeah.
and somebody else. So that was the case. What has happened? I said, if I remember correctly, it is section 15 of the Civil Courts Act,
Yes, my lord. Appeal, yes.
15.3.
15/3, my lord.
Yes, 15.3 stipulates that within 1 year, the DC has to dispose it off.
Oh, yes.
Otherwise, this person will, the district judge will do it.
Yes, you're supposed to transfer it, yes.
That's the, I think, the law.
Yes, my lord.
I passed the judgment. I'll give you a reference of that. We'll take it up on some other day.
My lord, I think I have that judgment, my lord.
Is it? Very good.
Yes, my lord. Yes.
You have it?
I think, my lord, I have, my lord. It's reported in GLR, my lord.
Ah.
Yes, I have it.
I'll just give it to you. This is it. 2023 1 JLR 188.
Yes, my lord, I have it.
The case of Tarong Yapi versus
Yes,
Taken.
Yes, my lord.
So that, I think, issue solves the problem, I suppose.
Yes, my lord.
Hello, we'll take it up on some other day. There's a stay or no?
My lord, I appear for a respondent, my lord. Respondent number 2. Mr. Genie used to appear, my lord, for the petition. I understand Mr. Loi is in Guwahati, my lord. He is supposed to appear in person.
Mr. Loy has left, my lord. I am engaged in this matter, my lord. I am appearing on behalf of the petitioner, my lord. I have filed my wakalatnama today.
Fantastic. So we'll have it on some other day. We'll finish it up. Because I think it's covered by my judgment on that.
Yes, my lord, and Civil Courts Act is now in place, my lord. There's
Hello, list this matter again on. We should have on 3rd of June.
my lord.
3rd of
My
June at 2 p.m.
My lord. Well,
My lord, in order number 40, in item number 44, my lord, it's an order matter, my lord. The respondent side has already appeared in this matter, my lord. So, my stay was until the returnable date. My lord, kindly extend my stay, my lord, in this case.
So all these stay orders which are there, what they have done. Let's see one thing. Stay matters are here. Okay. Stay matters are finished. Stay matters, what's this? What's this? ঠিক আছে এইগুলো স্টেজ যোনটো আছে নহয় এইবোৰ সার্ভিস হল নাই not 2024. It next week, বুধবারে আসুন 56 on Wednesday, huh? In time of the past shall continue till then. আর এইগুলো যোনবোৰ আছে নহয় সবতে everybody, all these transfer petitions, is there any agreement amongst the parties in respect to the transfer petitions for transfer? No. Everybody is contesting on behalf of the Wi-Fi on this side. You are for whom? You are a water source or what? Animal husbandry.
Mentioned one matter in the morning for urgency, Lordship.
Which one?
This is an unlisted matter.
I see. Okay, we'll take up your matter, don't worry. I don't know whether that matter is there. I'll sit out there, don't worry. For that, I'll take it out. Other matters, I'll take your dates, huh? Okay, I'll take her matter. Yes, madam. Your matter, let us see what you.
I for Lordship, the Secretary of the Demo Samavai Committee, which is a registered cooperative society since 8 September 1973. The area of operation is entire Demo Moja within 3,000 shareholders at present. Moreover, 5 numbers of shops were there. They were given it on rent. From 2010, the adjacent plot of the Demo Samavai Committee, Lordship, the Demo Municipal Board has established their office, and from that day they want to possess this property. And afterwards, Lordship, the title suit was preferred by the.
No, madam, first and foremost. FAO is filed by you,
Lordship,
challenging which order?
challenging the order, Lordship, and the IA, it is page number 12 in the IA, Lordship. 6th of May 2025.
Where is the
Lordship,
FAO court?
against a vacation of the ad interim injunction, Lordship.
Where is the FAO? FAO is dated what? You are challenging which order? 6/5/2025. Where is that?
Lordship.
Where is that?
This is page number 12 of the IA, Lordship.
IA. Okay. Where is that?
Last page, Lordship.
Without step of fees, today the reason is not interested to proceed the case, therefore is dismissed accordingly as party in payment of the executive. Yes, then?
Lordship, the matter is that on 5th of May, both the title suit and the mistake case were listed before this court. The
Before whom?
Before the learned senior
Ah.
civil judge senior division, Sibsagar.
Ah.
Lordship, on 5th, the petitioner before the Lordship given their hazira along with the extension of petition for extension of the ad interim injunction at 11:30. So they were order was passed that it is posted in the next day. But the title suit was posted on 16, next day it was fixed on 26/5/25. And later on, the injunction in the
But madam, I'm asking you, why have you filed the appeal here?
Lordship for under order 39, rule 1 and 2 for against this order of 6.
No, all understood.
For-
Understood. It is valued at rupees 12,50,000. How will the High Court exercise jurisdiction? I understand. The appeal will lie before the district judge.
We have already given 150 under 151 CPC there, but.
Understood, but my jurisdiction is only under that. Madam, kindly appreciate, my jurisdiction
sir, we have
is,
to
if I have the pecuniary jurisdiction, I don't have the pecuniary jurisdiction to decide that because the suit is of 12,500, 12,50,000. My jurisdiction only starts from 20 lakhs. Then how is that at all the appeal has been filed here?
It is filed on the ground on.
You can't
challenging
file
the
the appeal
order
here.
In the miscase Lordship only.
Huh?
Or on the order.
Or
in the
whatever
miscase.
may be, you can file under 227 is a different thing. I can look into that. That is a different thing. But how can I take to exercise the jurisdiction of an appellate court? I don't have the jurisdiction.
Yes, we have to file under 227.
No, you have to go and file an appeal before the district judge.
We have already filed in under section 151, Lordship.
Where?
The senior, district the senior division for restoration of the order.
For
Lordship.
civil judge senior division you have done. You have to file an appeal before the district judge if you want. You see, the question is,
For
the
pecuniary
order was
jurisdiction,
passed for dismiss for default. Okay, but you have filed an application under order 9 rule 9 there. Again, you are coming before this court. How is it possible? So many litigations you are filing. We do one thing. We take it up on Tuesday.
Yes, Lordship. We have the only problem is that they have already demolished and possesses our property. That is the only problem.
They have already done.
At least 50% they have done. We have annexed up photographs in the FAO, Lordship. Last page, Lordship, 57, 56 page number.
Oh, madam, you have to go and get a, yeah. The order is no, you can still file it there before the district judge. Go and file it before the district judge. You still have time. The order is on 6/5 only, na?
6/5 only, Lordship.
6/5.
Yes,
So
6/5
immediately file it there. I would, you file it tomorrow itself. Take the certified copy. Oh, no. You have a take a certified copy and file it there. Well, Ms. So-and-so, the council submits that taking into account the pecuniary jurisdiction of the court, the appellant would require to file the appeal before the district judge.
District judge.
District Judge Sipsagar.
Sagar.
It's a Sipsagar taking into account that the suit is valued at rupees 12,50,000. So taking into account the above, the instant appeal stands closed on withdrawal. Full stop. However, liberty is given to the appellant to immediately to proceed to file an application before the learned district judge against the order under against the order by which the suit was dismissed for non-prosecution.
It applies.
But you have also filed order 9 rule 9. How many you are going to do? I suppose.